Lordship, I beg to mention item number 5.
Item number
5.
yes.
Yes,
What-
I am for the respondent. This matter may be listed after 3 weeks.
No, but
I
who's
have
for-
taken consent from both the sides.
Who is for the appellant?
Yeah, I'm for the.
After 3 weeks?
Yes, yes, sir.
All right, you're Mr.
William W. Yirang.
On the prayer of Mr. W. William,
Yirang.
W. Liang,
Yes,
learned counsel for the respondent,
yes.
made with the consent of the opposite party. Hearing of this matter stands adjourned for 3 weeks. List accordingly.
Oblige, Your Honor.
My lord, I beg to mention item number 6.
Yes.
I'm here on behalf of the petitioner's counsel, R. Sonar, my lord. So this matter may be fixed on the next date of hearing, that is on 14th of May, my lord, after this general election.
You are for the appellant.
Yes, my lord.
Your name, please.
B. Nyarus.
No.
Mr. B.
Nyarus.
Nyarus.
Yes, ma'am.
Nonetheless, silent. Learned counsel for the appellant seeks adjournment of the hearing of this petition with a request to post the matter after 17th of May.
14th May.
14th of May.
14th.
Mr.
Yes, sir.
S. Lalit Diaz, AP is present and does not have any objection to the prayer. Registered to therefore list this case before a bench without one of us, after 14th of May.
Deeply obliged.
Yes.
Item number 1.
Your lordship here that received reply affidavit copy in just
Reply affidavit you have received just.
yeah this morning.
The person detained has been released.
Yes, sir, the issue may be rule may be issued fixed for hearing.
No, but what compensation you want here?
Compensation, you always see that there is illegal detention by the responding authority. Because the detainee is neither a part of the burn call nor the particular the participant in that burn call.
But this is writ petition criminal. This is
Yes.
a habeas corpus petition. How can you get compensation in this petition? You have to file a fresh writ petition.
Because you always see the detainee.
No, because it's filed. But in a criminal writ petition, how can there be compensation? You have to come up with pleadings, how much compensation you want, etc. And this WPCRC criminal is meant for release of the person. It's a habeas corpus petition. Think about it, up to you. Otherwise, these orders will be set aside even if you get it. Even if you get relief here, it will be set aside. So you have to think about these things and take appropriate steps.
You always with
You have not
Right.
understood. Not understood. Whether you do it today or after 1 month or after 5 years, same problem will be there. Anyway,
you always listed after 3 weeks.
Mr. So-and-so counsel for the petitioner submits that he has recently received a copy of the counter affidavit filed by the state and therefore 3 weeks time to file rejoinder. The prayer is not opposed by Mr. S. Tapin and his GA and ownership present appearing for this statement. In view of the above, this matter stands adjourned for 3 weeks.
Item number 2.
May I please, Lordship? Lordship, we have filed affidavit in opposition in respect of respondent number 7. It may be taken for hearing.
You are for respondent number 7.
Lordship,
Yes, you are for the appellate.
and Lordship, my senior counsel,
I'm
Is
appearing for the
there
respondent number
any-
7, madam.
is there in online.
Yes.
I'm appearing for the respondent number 7, madam. The affidavit has been filed today.
No, here the respondent appears in the right side, in the left side. Acha, respondent number 7 is file affidavit.
Lordship, my lord. I have given a copy, my lord.
You want to file rejoinder?
No, my lord, this affidavit, in fact, by the earlier order was, my lord, directed to be filed solely, my lord, the allegation that I have brought in the, my lord, writ appeal, and for the purpose of consideration of the interim prayer. Now, two allegations what I have put, my lord, with regard to the respondent number 7, that the average annual turnover should be 158.5 crores. Now, he has in form number A inflated 176 crore into, my lord, 1,726 crore. So thereby he became qualified. And the said form A is also, my lord, false document. It doesn't tally with the, my lord, CA certificate and the profit and loss account, which are, my lord, on record. Now the state government filed the affidavit with regard to that allegation, says that they are confining to the, my lord, form A, no other documents, whereas form A itself indicates what are the other documents to be, my lord, supplied. That is one. And secondly, another condition is that he has to complete a work of not less than 20% of the, my lord, tender amount in the instant case. So it comes to 63 crores and all. So that particular certificate which he has submitted, in fact, is a false document, and that has been withdrawn by the issuing authority long back. This fact, of course, we were not aware at the time of filing of the writ petition, but subsequently having, my lord, we came to know. So we have, in the review, we have taken that ground, but then the court observed that it may be a good ground in the appeal. So that review was dismissed. So therefore, these two count, my lord, firstly, that the form A is a, my lord, false document, as well as the completion certificate which has been submitted, that has already been withdrawn by the authority. And the stand of the state government is that since no complaint was received or nobody has objected to it, we have accepted by the same authority, the state PWD, the same UPI. That is the, my lord, two grounds, my lord.
So what is the interim order you are seeking?
My lord, this, my lord, apparently, my lord, the award of the contract to him, my lord, is illegal, my lord. Yes, and I have been ousted on the ground that I do not, my lord, qualify to the, my lord, clause 1.4, 1.7.4, my lord, which speaks, my lord, that 158.5 CR to be in average. But my contention is that it is directory. None of the, my lord, clauses in the tender document, it says if someone, my lord, secures someone, my lord,
Mr. Sekhar, what is the interim order you are seeking?
my lord, the work, my lord, further, my lord, continuation, you work to be, my lord, state, my lord, or at least, my lord, no payments will be made, and with in that case, my lord, the direction that the appeal be, my lord, disposed of within a, or the writ petition be disposed of within a, my lord, a fixed time, my lord.
We'll hear the writ appeal.
My lord,
We'll hear the writ appeal.
Lordship, yes,
Today itself.
Lordship,
Ready?
yes,
All right, Argu.
yes.
We'll hear it. Who is appearing for the respondent number 7?
I am appearing, my lord.
Yes. We'll hear the matter today
My
itself.
lord, my lord.
Yes. Which order you are challenging?
My lord,
Page 247, my lord.
Writ petition is still pending. Mr. Sekhar? It's pending. So this is against an interim order.
yes, Lordship. My lord, the Honorable Siligius, my lord, on the first day, my lord, at page 243, 24/1/2024 was passed. That's for, and my lord, very short duration till the instruction, received the instruction, and accordingly interim direction was issued at page 244. It is however provided that in the event of financial bid are opened, today no final order of allotment passed till the next date fixed. Now, my lord, on receipt of the instruction, the next day was
No,
moved, my
you
lord.
are challenging the order dated 29/1/2024.
My lord, I am challenging 29/1/2024
Let us read the order, please.
as well as the review order, my lord. But
Review
here, my
order
lord,
is, you can't challenge. Review order is over. If the review is dismissed, that means this order holds the field.
Lordship,
Yes.
Lordship, my lord. So, my
But
lord,
that is because order 47 rule 7 says so.
exactly.
Yes, let us read this order
Lordship.
29.
My lord, this order, my lord, with regard to, my lord, the court confined, my lord, with regard to the interpretation of clause, my lord, 1.7.4. My lord, I had submitted that in any of the 5 year, if I complete, my lord, 158 crore, 158.5 crore, in that case, that would suffice. Then from the government side, it has been said that no, it is the average has to be, my lord, taken into note, and average it has to come to 158.5 crore, and on that ground they have rejected 4 others, and no other points, my lord, whether this quoting a lesser amount, because my amount comes to about, my lord, 120 crores and odd, my lord, whether by quoting a lesser amount it amounts to rejection, because the
We'll
technical.
see those things. Let us first read.
Yes,
this
yes,
order,
yes,
which
Mr.
is- It's filed today.
Lordship, may I read, my lord?
You have received this affidavit.
Yes, I have received it.
You don't have to file any rejoinder.
Nothing, my lord.
Yes, please.
My lord, I'll read from the 3rd paragraph. It is submitted that one of the requirement was with regard to the financial soundness as given in clause 1.7.4. As per the said clause, a bidder should have average annual financial turnover of not less than rupees 158.5 crore on any works contract during last available 5 years, balance sheet duly audited by the chartered accountant. By drawing the attention of this court to the financial information given in Form A and Annexure 4, the learned counsel submits that for the year 22-23, admittedly the figure is 1584.13 lakhs, which is more than the minimum requirement. It is contended that meaning which is assigned to the requirement of clause 1.7.4 is to have met the minimum amount in any one of the last 5 financial year. Countering the said view, Sri Tapan Learned Senior Counsel Advocate, however, submits that the interpretation sought to be given on behalf of the petitioner is prima facie not tenable, as the expression used is during and not in any one of the last 5 years. He has also submitted that it is the average annual financial turnover for the last 5 years which is required, and in any case the subtle position of law is that the interpretation of the author in a contract document is to be construed as the best interpretation. Sri Tapin further submits that applying the same clause, the bid of 4 other bidders have been rejected, and there is no mala fide in the impugned action. He has placed on record the written instruction received by him. So accordingly, madam, the second last paragraph, the court is of the prima facie opinion that the interpretation sought to be given on behalf of the petitioner is not legally tenable. Be that as it may, it is observed that all action pursuant to the so-and-so shall be subject to the writ petition. And against this order I have come, madam. The issue basically was whether quoting a lesser amount entails rejection of the tender, or it can be declared non-responsive. The Schedule D, which is the process for evaluation, that provides for marking. Lordship, will you kindly see
Where is the clause you are referring to? 1.7.4. Where is it?
page 61, madam. Page 61.
61.
Lordship. 1.7.4, financial soundness. The bidder should have had average annual financial turnover gross of not less than rupees 158.50 crore or any works contract during the last 5 years, balance sheet duly audited by the chartered accountant. Any works contract during the last 5 years, that's what we stress, and we said that any years, if it is above the 158 crore, in that case, this will meet the particular requirement. And the government submission was by taking note of the average.
So you are saying the average should be in any 1 year of the last 5 years. And they are saying
In
it should be
5 years,
average.
in 5 years, in any year, average is 158.5 crore, that would meet the requirement. That
And according to them, it should be the average of 5 years.
the average of 5 years.
So does the private respondent meet this requirement, average of 5 years?
Otherwise, not had that document not been, my lord, fraudulent.
Please
Lordship, my lord, Lordship.
respond. We'll come to your case.
Yes, yes, yes.
And we'll hear your arguments,
Lordship.
don't worry. But please give us the clarificatory.
Lordship, my lord.
The whole controversy revolves around interpretation of 1.7.4, correct?
For time being, my lord, if it is in either way also, my submission would
Mr.
be,
Saika,
Lordship,
I
Lordship.
think, sorry to say, you are too stuck up with the preparation you have made. You
Lordship,
are not probably
Understood.
understanding the query we are
Lordship,
making.
Lordship, Lordship,
You argue your case as you have prepared,
Lordship.
but please give us the answers we want first.
Lordship.
Then you are free to argue your case.
Honorable single judge has confined, my
We are
lord,
asking a simple question.
Lordship.
The entire controversy revolves around interpretation of 1.7.4. Is that correct?
Lordship,
Or is there anything else?
nothing,
Nothing else.
nothing.
So 1.7.4 is the financial soundness criteria.
Thank you.
This criteria, according to the department, is that 158.50 crores should be the average of work executed over the last 5 years.
Lordship.
So 1 year it could be 258, another year it could be
Maybe
only
zero
58,
also. Lordship.
zero also, but when they add up all the figures,
It should meet
the
one.
total amount divided by 5 should not be less than 8.50 crores. That's the department stand.
Stand.
Your stand is that no. In any one of the 5 years, if I have executed work more than 1.5 crores, that's enough.
That is.
The other year it could be 0, it could
Lordship.
be 10 crores. That's the case.
Lordship, my
That's
lord,
the
that
case.
is only with regard to the interpretation of this particular clause, my lord. My basic, my lord, contention was that even if, my lord, if someone, my lord, puts lesser than this does not entails rejection. It is not a mandatory condition as such because of the evaluation process that has been given. There,
No, there is a
Lordship.
problem with this argument. Let's cut the long matter short.
Lordship.
While exercising jurisdiction under 226, the Reed Court will only see one thing,
Lordship.
whether they have acted in a malafide and arbitrary manner,
Lordship.
discriminatory manner. They have done something wrong, we will not touch it. Let's be very clear.
Lordship.
And that's the law.
Lordship.
Whether they are right or wrong, we are not going to go into this. We will only see whether they have used different yardsticks for different contractors, thus discriminating one contractor against the other. If you succeed in that, we'll interfere. If
Yes.
you don't,
Yes, yes.
we'll dismiss.
Yes,
Let's be very clear about it.
Lordship.
Whether they are right, wrong, their understanding is okay, not okay, we will not even whisper on that.
Lordship.
They may be wrong. But are they uniformly wrong with everyone?
Lordship.
That's the only question.
Lordship.
So you have to show us that this interpretation they have adopted, they've applied differently to different contractors,
Lordship.
as a result of which one has got the advantage, other has not.
Lordship.
That's the only sphere of the matter.
My lord, my submission would be.
Please,
Lordship.
please appreciate. I don't know what my brother will say. We will go by the established principles. We are not settling tenders. We are also not awarding work. We are not floating tenders. This is not the job of the High Court. We will only protect the rights of the bidders as guaranteed under Article 14.
Yes.
Nobody should be discriminated. People should be treated equally. That's all.
That's all.
Not an inch more than that. Whether the department is right, wrong in their understanding, we are not concerned.
That's all.
If they are wrong, and if they do something, the audit will take care. This is
Right.
not for the High Court to look into.
Right.
Show us that this
Madam,
clause has been
my
differently.
only submission, I just want to add one that, madam, this
Yes.
1.7.4 has to be read with, madam, Schedule D, which gives the bid evaluation process.
Mr. Saika,
Right.
you argue we will not consider.
Right.
You have to show us that they have used this clause to discriminate against your client.
That's it.
Whether they are right or wrong, we will not even consider your argument.
That's it.
That's not our job.
That's it.
We are not sitting here to find out whether the department has come up with the right contractual clause, whether they have understood their clause correctly. We are not concerned. We will go into it if only if there is an argument that by interpreting the clause differentially, they have used their powers to discriminate one contractor against the other. If you succeed in that, we'll set aside the contract.
That's it. Madam,
Only argue on that. They are right in their understanding. We will not go into that.
that's
So
it, madam.
please don't labor on that.
No, my lord, even, my lord, for a moment, my lord, even if I accept, my lord, that the submission that had been made by the, my lord, or the interpretation that has been accepted by the Honorable Single Judge stands, my lord, Then so my main argument in actually, my lord, that the tender committee did not have power and jurisdiction to reject because this particular, my lord, clause, this 158.5 crore is not a mandatory condition, and which will reflect in Schedule D. That was the, my lord, main question what my lord, was to, my lord, raise before the honorable single judge, but having failed to do that, my lord, I have in a review.
That matter will have to be decided in the writ petition.
Rachel,
Is it not? We are hearing a writ appeal against an interim order.
Rachel,
So whatever is reflected in the order of the learned single judge, we will confine the considerations on that.
Rachel.
The writ petition is still pending,
Repression is pending.
right?
Repression.
You must have taken other grounds also in the writ petition.
Rachel.
That writ petition, we are not deciding. We are
No,
only
madam.
deciding the appeal. Insofar as the single judge has declined your prayer for an interim revision. That prayer was made primarily on the ground that they were wrong in their interpretation of 1.7.4. Is that correct?
My lord, that's what, my lord, my submission is that my point was, my lord, that the tender committee do not have power and jurisdiction to reject a tender under clause if someone, my lord, comes lesser than the amount as mentioned is 1.74. But then the honorable single judge has confined it to only interpretation of the clause 1.7.4. So those, my lord, grounds having not raised before the honorable single judge, though a writ was preferred earlier, I have withdrawn it, and then a review petition was filed before the honorable single judge by raising all these questions what I am now raising also, my lord. And the honorable single judge said these are the good grounds for appeal, maybe good grounds for the appeal. So hence this appeal is, my lord. So review petition, in the review petition, all these questions have been raised. That has also been, my lord, to some extent recorded in the review order, which is also annexed here, my lord. So now the question your lordship will decide, my lord, perhaps, my lord, whether the tender committee has, my lord, rightly rejected, or whether they had the, my lord, power and jurisdiction to, my lord, reject this particular, my lord, the tender on the ground that I have quoted less amount. And my lord, submission is
They
that
quoted less amount means the tender, the financial bid. Less amount in the financial.
no, my lord, this technical bid with regard to clause 1.7.4 average annual turnover. There is one of the clause
So this is
1.7.4
a two bid system.
two bid system. This is on the
And
technical
you have been ousted in the technical bid.
technical bid, my lord.
Now you know the price quoted by the private. Who has backed the work? Seven. That's
Seven.
what I said.
315.
Have
He
you
has there.
quoted lower rate than him?
No, my lord, the financial bid will be called only from the, my lord, responsive bidder in the technical bid.
Okay,
So I
so-
was not invited.
But a financial bid was not submitted along with the technical.
No,
bid.
no, my lord. As per the tender clause only, the successful bidder will be called for financial bid. Now, with regard to the allegation that, my lord, for a moment, my lord, with regard to the allegation what I have, my lord, made against the, my lord, respondent number 7, my lord, 176 crores for the year 2018 and 19 has been inflated to 1,726 crores, and thereby they could come to the, my lord, this minimum average turnover of 158.5 crores. Had that been, my lord, noticed by the taken into consideration, the document itself is false. My lord, on that ground, the clause provides any documents, my lord, which is, my lord, fraudulently submitted or false documents submitted, it entails rejection of the tender.
That is by the respondent number 7.
By the respondent number 7. These are, my lord, apparently, lordship may kindly, if looks into the, my lord, page 78 for a moment, my lord.
Yes, page 78.
78. This is the Form A, my lord, where annual turnover for last 5 years to be provided.
Yes.
Well, the financial analysis, details to be furnished duly supported by figures in the balance sheet, profit and loss accounts of the last 5 years, financial years, duly certified by the chartered accountant as submitted by the applicant to the income tax department, copies to be attached. So not only figures, but also copy of the last 5 years loss and profit, and the document that has been submitted to the income tax department by the CA has to be attached. So the figures has to match there, my lord. Now your lordship may come to my lord, page 155. This is the form A submitted by him, my lord. Now for the year 2018-19, lordship will see 172625.73. My lord, this is given in my lord lakhs. If it is my lord, converted into crores, it would be 1726.26 crore. Now your lordship will go to the next page. This is CA certificate that has been given by the chartered accountant. Page 156, serial number 5. This is 17625733329. Now, in between the word 7 and 6, they have inserted 2 of their own and submitted in the form A. So thereby it became 1726 crore, and whereas the turnover certificate that at 156, it is only 176.26 crore. The affidavit, they said, we will go by the form A, will not look into the other documents that have been submitted. This figure again fortifies your lordship will kindly see the.
All right, so we have understood. Now, please.
Had this
report
amount.
on one count.
Lordship.
Apart from you, there were 2 or 3 other bidders who have been rejected on the same ground.
On this ground.
On the same ground. Now, you say that the financial bid, neither your client nor those 2-3 bidders have submitted their financial bid, because you are all ousted in the technical bid.
Technical bid.
Work, there can't be a mandamus to give you the work. Even
No,
if
no,
you
no.
succeed.
My lord, my submission, the entire my lord, bid evaluation process was wrong, my lord. It was
You are not
lordship.
understanding.
Re-evaluation would be required, my lord.
Re-evaluation of your bid or all the other 4?
My lord, since others are not coming before your lordship, it will be up to my lord, the lordship as desired, my lord. But normally, my lord, since my lord, if the same illegality has been committed to others also, they should also be getting the benefit. This is then your lordship will, I have shown this my lord, page, and then the profit and
How much work has been done already? How much?
Well, the government says 32.5% of the work. They also said, but so far as my lord, amount is concerned, my lord. Sorry, my lord. Both of them said 13 kilometer and they have formation cutting completed. Now, so far as the government says, the cost value is 32.5 crores and it amounts to 32.5%. Whereas the private respondent says it is 18% and the amount is 49 crores. And I have a document to show, my lord, that formation cutting was already over, my lord, there. And from their own affidavit, your lordship will find 6/2/2024, the LOI was issued. Bhumi Pujan was done on 9/3/22. 24, 9/3/24.
1 minute.
Income tax.
Mr. Saikia, we want to share with you what we have in our mind. And the reason we are not required to share, but the reason we are doing it because we want transparency in the thought process and in the stay of work is rejected, will not stay it. But since you're taking an allegation of fraud, we can tell them that let him continue with the work, payment up not beyond 70% will be released. And we'll request the learned single judge to hear the writ petition on merit. Only because you have taken the plea of fraud. On your interpretation, we are not convinced. But we'll not say anything on that. If you succeed in establishing fraud, then consequential action will follow, and you will also be entitled to claim the profit component and credit for the work, since you have pursued the matter. That's the order we propose.
My lord, that is apparent, my lord. That's what I'm submitting. My lord, these two documents and the third document at page 160.
There are amendments to the specific relief act. So infrastructure matters, stay of work. Now, we have rejected it. Take it that we have rejected.
No, my lord,
that we are
yes,
not-
lordship would definitely, my lord, referring to.
Whatever be the
Lordship.
ground, we will not stay the work.
Lordship, my lord,
Because rainy season is coming and the public suffers.
lordship, my lord.
Your client gets the work or respond.
But then, my lord, the public money is involved and my lord, the manner in
That's
which
why
it
we are
is
saying
settled.
we are protecting the
Lordship.
public's interest.
Lordship, my lord. My lord,
In
no,
these
no,
matters,
Lordship.
we are primarily concerned with the public.
lordship, my lord.
Thank you for bringing it to the notice of the court. We will examine into the matter. If there is really a fraud committed by him, consequences will follow. So 70%, 30% is approximately the profit minimum. That
My lord,
money he
no,
will
my
not
lord,
get.
sorry, my lord, sorry, I'm sorry, really sorry, my lord.
That money he will not get if you establish fraud. And you will also be entitled to claim credit for the work, believing that the work was executed by you. If it is proved that the respondent number 7 backed the contract by practicing fraudulent means, only then. That's the order we propose to pass.
Malad-
You are free to argue for the half of the day.
Lordship. My lord, at this stage with the prima facie, my lord, what is, my lord, whether fraud has been committed or not, my lord. My lord, two documents I have shown.
That the single judge will have to decide, because we can't give a view on that.
No, my lord, that has been raised before the honorable single judge in the review petition. He did not, my lord, said this may be a good ground for appeal, whatever, my lord. So did not entertain. Therefore, my lord, I am raising this question, my lord. These were all being raised. The review petition is also there. The submissions are also my lord, recorded my lord, to some extent, my lord.
You want to press fraud in the writ appeal or in the writ petition?
My lord.
You want to press the allegation?
My
of
lord, this
fraud?
appeal is basically against the, my lord, interim order, my lord.
That's right.
Interim order, my lord. So the merit that has to be heard, but for the prima facie satisfaction of your lordship, my lord, the act of fraud, my lord, what, my lord, I am trying to say, my lord, it is so apparent.
You are pressing that to stay the work. That's correct.
If, my lord, since lordship has taken a view that progress has to go, but whether in the wrong hand it should go, my lord. My lord, the NJ, my lord, that project case, my lord, that has again been, my lord, considered by the, my lord, Apex Code in, my lord, Jai Bhula Nath case, my lord. There it says if it is so apparent, then in that case, my lord, it should be stayed, my lord. That should go in that way, my lord.
Right.
Lordship, my
You
lord.
conclude your arguments.
Lordship,
Then
my lord.
here they will pass the order.
Lordship, my lord. No, my lord, the second document, your lordship will kindly see, my lord, at page 160.
160.
160.
160.
160. This is the document submitted by the CA before the income tax authority. As per the Form A clauses, my lord, the first document I have shown the profit and loss account. It is only for prima facie satisfaction of your lordship that fraud has been committed, my lord. Page 160, lordship may come to, my lord, the serial number 2. Down, my lord,
Yes.
on the right hand down, my lord, figures particular. Serial number 2. Gross annual turnover on construction work 2018-19, 17,625.73 lakhs. Now your lordship may come to, again, if you look back at the, my lord, page 156.
Yes.
$155 million. this is 172625. This 2 has been inserted. This 2 has been inserted. Page 160 and page 155. This 2 has been inserted. And this Form A is also false because your lordship will kindly see at page 160 the UDN number. UDN number at page 160. It is dated 17/11/2022, 13/6/55 time. And the number is this, my lord. So this number has been generated on 17/11/22 at so and so time. My lord, this same number has been, my lord, mentioned in form number A, which cannot be generated in any other day except that day, my lord.
So which figure is correct?
My lord,
One in
this
page 155 or one in page 160?
160, my lord. Form A he can fill up, but that has to be supported by the audited balance sheet, profit and loss account, and the document which has been submitted to the income tax department.
What is this document at 160?
160. This is the, my lord, document, 5 years, my lord, this CA has, my lord, submitted before the
Yes, yes, it should be, yes.
CA has submitted before the income tax department. So in proof to, in support of the, my lord, the clause, my lord, that has been referred in form number A, that the document which is given to the IT department. So for that context, this has been, my lord, submitted. This is the actual one. They are only, my lord, 17,625 crores. And in Form A, which is to be inserted by him, it is 17,265 crores. And the UDN number, this particular document at 160, that was submitted to the, my lord, income tax department on
These are
17.
all part of the writ petition. These
My lord?
documents, these are part of
Part
the
of
writ
the-
petition. You have taken this plea before the single judge.
My lord, in the review we had taken, because on the first day we could not, my lord, as I said, my lord, the
No,
single judge.
Mr. Saikia,
Lordship.
we are sorry to point out, you are again and again referring to the review. Review is only for correction of an error apparent on the face of the order.
Lordship,
Review is not to consider new points, new
Lordship.
pleas,
Lordship.
right? So the learned single judge has held that none of the features of review application were present in your review petition, so it was
Lordship.
declined by giving you liberty to raise the issue before the appellate court.
Appellate court.
Now, before the appellate court, you are demonstrating that there is a mismatch of information.
It's a fraudulent dog, false
That's
document.
according to you.
Lordship.
That's according to you. We can't investigate on this.
Lordship. It is only for prima facie satisfaction. That investigation has to be, my lord, they are also not, the government is not saying no. Government is saying we will be, we have confined only to Form A, no other documents. Which they were obliged to do, because those documents were also called for to, my lord, match the figures, whether the Form A has been rightly or correctly submitted or not.
Form A is in page 160.
155.
That is Form A.
Form
Form A gives the correct figure. According to Form A, he is eligible.
My lord,
According to the figure shown in Form A,
he becomes eligible,
eligible. But
but
that does
actually
not
he
tell
is
you
not.
that-
Lordship.
That is, that doesn't tell you with his account audited
Amount,
amount shown in the CS
yes.
report. That's
C-
the only point.
CS as well as this income tax certificate, he would have been, my lord, somewhere in between 149 crores or so. He cannot reach the 158.
Right, so we'll ask him, what is the, we'll ask him.
Lordship, that is one, my lord. The second, my lord, the another clause 1.7.2, my lord, that requires a similar job, my lord, completed of what, my lord, 20% of the tendered value. 317, it comes to 63. My lord, that completion certificate, what they have given, this, my lord, particular ground, my lord, information we came to know after the, my lord, filing of the writ petition, after the interim order. So this was also taken in the review petition. My lord, the department themselves has, my lord, my lord, before the NHIDCL said, this is a false document. We have withdrawn it. So, my lord, these two, my lord, not only this, this turnover, but also with regard to the other clause 1.7.2, he has submitted false document, and the clauses says that tender has to be rejected. But before the honorable single judge, my whole thing was proceeded. This is not mandatory. This is a directory clause because of the schedule D, which prescribes making of marks. If your lordship kindly have a look to the schedule D for a moment, my lord.
Which one?
Schedule D, my lord.
Schedule D, page number.
Page 87, my lord.
Yes, please.
That's it, my lord. The clause 6.1, bid opening committee during the opening of technical bids shall verify the following documents uploaded during bid submission, original or downloaded copies as a prerequisite for carrying out further evaluation of technical responsiveness of bidders. So that document is only proof of payment of bid fee of rupees 25,000. But the receipt has to be uploaded. This allegation also I have taken. So far as the respondent number 10 is concerned, he has given the draft itself, not the receipt. Whether he has paid or not, the proof is not there, but a draft is there to show that this is a mandatory condition so far as further proceeding with the evaluation. If this is not satisfied, in that case, my lord, his bid cannot be open. So far as respondent number 10 is concerned, though he is declared as responsive, he did not upload this receipt. The receipt is given in form number G. That is one ground, so far as respondent number 10 is concerned. How they have been arbitrarily proceeding, that is on that point, then your lordship will find 6.2, in addition to fulfillment of requirements laid down at Schedule C, technical eligibility of the bidder shall be determined based on minimum score shown below. Well, Schedule C refers to the mandatory documents which are to be uploaded. I have uploaded all documents. So therefore, they have proceeded for evaluation. Now, evaluation, they have said that you don't have 5 years average of 158.5 crores. So your tender is rejected. But the particular 6.2 says, for that you have to provide marks. This form A, financial strength maximum is 20.
Have you seen the amendments brought to the specific relief act regarding infrastructure?
Lordship,
You are aware of that?
Lordship. This is, that's what I said. The NG products was so far as this the progress should not be
I will
hampered.
not stall the work.
Lordship,
Question doesn't
Lordship.
arise.
At least in that case, my submission would be, my lord, no payment shall be made and a fixed time may be given for disposal of the writ petition, my lord.
Consent.
Because he has not executed the work also. Now that 18%, 20%, what has been submitted, my lord, these are the photographs, my lord. If an inquiry is done, these are all prior to, my lord, the LOI have been issued. This is of, my lord, 18/12/2023, my lord. These formation cuttings are already there. Now the bills have been submitted, which are already done, my lord, and trying to say that 18% he has completed.
Yes.
So, my lord, payment, my lord, he has not done any work, my lord. Because on 9/3/2022 only, 24 only, the Bhumi Pujan has been done by the Prime Minister. My lord, no work can start, my lord, prior to that, my lord. So my submission, my lord, your lordship is not, my lord, going to study process. At least the payment should not be given to them at all, my lord. And any weekdays time or any day, my lord, the entire writ petition can be heard. They have filed the affidavit in the writ petition also. If required, will file.
When do you want to argue the writ petition? Pleadings are complete in the writ petition?
They have filed, my lord, so far as the respondent number 8, 9, and 10 are concerned, since they are not contesting, and LOI has already been issued to them during the at the time of filing, the financial bid was not opened. And since they are also not continuing, I may, my lord, delete their names also, that would not, but so far as the private respondent is concerned, they have filed the affidavit in opposition.
So pleading-
Respondent number 7 has not filed, government has filed.
No, respondent number 7 has filed affidavit in the writ appeal.
In writ appeal, my lord. The stand, even, my lord, stand cannot be, my lord, deferred, my lord.
So we'll say that this affidavit will be treated as counter affidavit filed in the writ petition.
Even if they wish to, my lord, file additional, my lord, they may file, but a fixed period, my lord, and my lord, till then, at least, my lord, the payment should be.
Agree on a date, agree on
That's
a
right.
date.
During this time, if you wish to continue, let him continue with the work, my lord. But, can be on 28 March. Today is,
Now the client is speaking, not the lawyer.
let's,
Obviously, you can't have it on 28th March. Think of a date. We'll put it on 22nd April.
22nd.
You can just tell us if it is convenient to you.
That's
22nd April.
No, otherwise it will be convenient.
22nd April is convenient.
Second.
But only my prayer will be, my lord, no payments should be released till then, my lord. That is, my
We will put some cap, not no payment,
my lord.
70%, beyond 70%.
70% of the total work.
Total work.
But total work is for, my lord, 3 years. And, my lord, what they are claiming, the private respondent claiming 18%
We'll
work.
make it clear, if you succeed, you will be entitled to claim damages as disgorgement of contract and credit for the work. If it is shown that he has got it through fraudulent means, that will make it very clear. You'll be entitled to claim for that. You can't execute the work, that's over.
No, that
You
is
can
there.
get credit for the work and the losses you suffer, if at all, that will be offset from the amount of 30% which will be due to the contractor. He proceeds on his risk and cost. That's all.
My lord, since, my lord, the lordship is not staying, they can proceed with the work only the, my lord, if it is shorter date. My lord, if, my lord, I succeed, it will be retendered, I'll be able to, or re-evaluation, I'll be able to do
Yes,
that, my lord.
yes.
So, my lord, if I don't get the work to be executed, my lord.
See, the problem is,
That's my
the
lord.
moment the court tries to be frank, the system gets derailed. We asked you, the date we could have put in the chamber also.
That's
We asked you because we wanted to ascertain your convenience.
That's-
We will definitely fix it on 22nd.
that's-
And 70% will be the ceiling that we have indicated to you. Otherwise, we
Right.
could have kept quiet and passed the order in the chamber. We are thinking about balancing equity. We are not turning down your client's request. But your client has to understand there are limitations in these matters. So if the 30% amount is kept reserved, in the event you succeed in the writ petition, still some remedy can be given to your client. That is the idea. All right. Your client cannot execute this work unless you get an
Yes,
order
that
from the
is-
superior court. That he has to forget. But he can still claim credit for the work on the ground that he has been wrongfully denied. For that, you have to amend your pleadings.
That's my lord. That,
Yes, that will take time. This matter will not be heard in October also, take it from me. If you are to get any relief, even October it will not be heard. Because unless you amend your pleading, you can't get any relief here. I have seen your pleadings.
that's
You have missed the bus on your pleadings. It is not for us to give suggestions,
no, no,
but
that's,
we are pointing out because we are interested in justice.
that's,
Unless you have these pleadings made, how are you going to claim these reliefs? Otherwise, a simple order of rejection of your interim prayer, that's end of the road for you. We are thinking a little ahead.
That's-
Balancing public interest, not completely ignoring your grievance. This is the way forward, we think.
the subsequent events, my lord, I'll be bringing to the subsequent events. Because on the
this will
date
take
of filing
time.
of the writ petition, financial bid even was not invited or called, my lord. So,
You press these points,
lord, my lord.
get an order on merit.
Yes, yes,
That's
yes.
it.
That's-
It will take time. In the meantime, the work cannot suffer. Whether you do or the others, respondent number 7 does, the public is not bothered. People want the road to be ready, that's all. And the courts will work towards upholding public interest, always. If there is a conflict, public interest will take primacy over private interest.
That's-
That is why we are saying that we'll fix it on 22nd April. And you examine whether you need to amend your
Yes.
readings in the writ petition.
Well, in between the
But there
pleadings
are
will be
judgments
completed, but that
that
observation. my
This court has passed, sitting singly, I passed orders earlier also regarding disgorgement of contract. So you build up your case on that. If you can establish fraud, maybe you will be entitled to some relief. If you can't, then difficult. Fraud is a very serious matter.
That's
Fraud
what my lord,
dictates everything.
lordship.
If it is that its turnover was not with the two, but less than that, and he has given a forged document, then the entire thing will go.
And they are not disputing, these are, the other documents
They may
are,
not dispute,
Yeah,
but
that's
the
it.
court has to give a finding. You haven't lodged an FIR.
lordship.
Have you lodged an FIR? No?
My lord, these are, my lord, I have pursued the writ petition, my lord, those will be there.
These questions will come into play.
Yes, on the basis of the undisputed, my lord, these documents, they are not, this is their document only, my lord. That's right. Lordship will observe, my lord, for the second in between, if any pleadings, my lord, party may exchange, my lord, that,
Yes.
and if some more amount can be retained, my lord.
Lordship, just I would like to point out one thing also. So far the issue of fraud is concerned, that has not been pleaded in the writ
Issue
petition.
of
This fraud lawsuit, fraud submitted. That is not the pleaded in writ petition lawsuit. Now we are examining the correctness of lawsuit that interim order. Lawsuit, this, when this issue is not before the learned single bench, whether this honorable court was sitting in the appellate forum also, can consider that or not?
we will not. That's what we've indicated. We are not going into fraud.
Yes, Lord. Because lawsuit as concern is so is of the fraud lawsuit.
There is no pleading of fraud in the writ petition.
No, no.
It's correct. You said you have pleaded fraud.
My lord, in the review petition, we have pleaded, my lord.
And this, all these,
So this subsequently we came to know, my lord. It was not, my lord, before that, my lord. We came to know subsequently. So the subsequent event we tried to place. Because while evaluating bids, my lord, parties are not allowed to be. It is only at the bid opening only confined to.
if lawsuit see the writ petition lawsuit, the prior lawsuit. Here lawsuit, the
Where
issue,
is the prayer? Which page?
lawsuit, writ petition starts from page 25 lawsuit.
Page 48.
And prayer is at page 48 lawsuit. Here lawsuit, before the learned single bench lawsuit, only two issues lawsuit. One issue lawsuit, whether lawsuit, the technical bid of the petitioner has been rightly rejected or not. That's the one issue lawsuit. Secondly, lawsuit, this private respondents lawsuit, or private respondents, whether they are eligible or not. These are the only two issues before the learned single bench lawsuit. And on this same issue lawsuit, when interim was not, it was not considered lawsuit. It was not granted lawsuit. Writ appeal was filed lawsuit against this very same order lawsuit with same prior lawsuit. And this honorable court, while sitting in the division bench, the interim was not granted lawsuit.
Oh, where is the order in the earlier writ appeal?
Yes, lawsuit. Kindly come to page 1, lawsuit.
It was never rejected. Notice was issued.
Prayer was there lawsuit.
Where is the order? Where is the order?
Page 247 lawsuit. Page 247 lawsuit.
254, my lord.
Sorry.
254 is the 250.
Sorry.
254 is the withdrawal order, my lord.
Mm.
254. 250.
Achha, you preferred a writ appeal earlier.
Earlier,
Then withdraw it and then file review.
Then file review.
Because
Then again file the writ.
Again, this.
Because these are all, my lord, subsequent event, my lord, which we came to know, my lord, and the points which were raised, my lord, ought to have been raised, were not raised before the single judge. So, my lord, realizing that, my lord, we have withdrawn the writ appeal, and my lord, though it was, my lord, decided to file a
Where
writ
is the
appeal.
order of withdrawal of the writ appeal? Where is the order of withdrawal?
Review application.
256. my lord.
Review application, find that, my lord, 279.
Order on review lawsuit 279 law. And that order has not been annexed. I'm sorry, lawsuit.
279.
Relevant to come, my lord, from 287 or 286. Review application also we have kind of filed.
There is no pleading of fraud in the.
No.
No, we did, my lord.
Where is it? Just show it, please.
Well, page 34, Lordship, may I see? We did not lodge, my lord, the completion certificate is false. That we could not because we did not know about it, my lord. Page 34, my lord. My lord, clause 8.2, that the turnover certificate of rupees 176 so and so of respondents were as per balance sheet and profit and loss account duly authenticated by the, but in form a certificate financial information so and so, whereas annual turnover as per balance sheet and so is 17625. As such, there is excess of annual turnover so and so, which is not at all possible and is not correct and does not match with as per the balance sheet and profit and loss account of the chartered account. Next, that then 8.3, that as per the records, the EBN number so and so is generated ID for the financial year 2018 to 2021, 22, but in the financial data so and so is shown for the is a fake and fabricated. The generated EDN number is available in the website of the Institute of Chartered Accountant of India, and as per records, said EDN was generated on 17/11/22, but the Form A EDN have been shown to have generated on 10/10/2023 as Form A is fake and fabricated one. Apart from that also, this Form C also they have manipulated. The Form C should contain the 10 column. The last column is that to show whether it is a completed on back-to-back basis. That column they have skidded. In their form, only column 9 is there. That ground is also given.
I'm sorry, I overlooked this clerical procedure. Sorry.
Only one ground I could not
sir,
take. That is with regard to completion certificate, because we came across the NHA DCL certificate subsequently, where from it reveals that particular completion certificate is fake. So we have taken that ground in the review also.
All right, now in your counter affidavit, what is your reply to this paragraph?
No, sir, counter affidavit is not annexed here, though.
Before the writ court.
Report a report.
Yes.
Same allegations are here in the before in the writ appeal also. No, writ court or writ petition only.
No, is there a counter in the writ appeal?
Yes, ma'am. By the
Any
government.
response?
They said they are confined to the Form A, no other documents. Because there is an affidavit, so they don't need to go the other documents.
What is this Form A? This is a. What does
Form A is
mean?
the my lord, that financial turnover to be supported by the profit and loss account and the income tax return duly certified by the certificate and the copies of those to be enclosed.
Right, so you are showing a mismatch. Nothing to whether Form A is or the audited balance sheet is correct.
But
We can't readily conclude that Form A is wrong and that is correct. We can't do that.
Form A to be filled up by the candidate, the bidder. It has to be basing on the this profit and loss account and the income tax return duly certified by the chartered accountant. So what is, if it is not in consonance with those documents, so that figure cannot be taken into consideration, because for ready reference, this amount has to be quoted. Otherwise, profit and loss account or the income tax return would have sufficed. But for ready reckoning of the technical evaluation committee, the figures, you mentioned the figures. And while mentioning the figures, from 176 to they have made it 1076.
All right. Now, how much of work has been done?
No, the progress report is here. It's on 10/3/2024.
Yeah.
The process, first page, second page, first page.
What percentage? What percentage?
Jungle clearance is almost 84%. Jungle clearance. Formation cutting was 38% already completed. First jungle clearance, then only formation cutting, and then loss of that carpeting and all.
And the respondent number 7 says it is only
Yes.
18%.
This completion has been geotagged.
They said 49%, respondent number says himself who is executing, he says 18%.
Yes,
And this lawsuit, this particular issue lawsuit. On these two ground lawsuit, the appeal was filed lawsuit. And on past day lawsuit, when it was
the
moved,
appeal was withdrawn with liberty to file afresh.
that's correct. What I'm just trying to point out is. Past day when it was not granted, only notification. On the ground. And some it was interim was not granted, then they went to lawsuit, review court lawsuit. They filed review lawsuit, taken this additional ground lawsuit. As of now lawsuit, apart from these two grounds lawsuit, raise issue jurisdictions of the competency committee and this bar by this LBC lawsuit. All these issues are not before the London Supreme Court. Not even they have filed additional affidavit bringing on record all these issues.
But that's correct, but you also not specifically traversed the allegation of usage of fabricated false document.
So for this lawsuit, Form A is the requirement lawsuit, Form A. If lawsuit see the Form A and supporting documents, one lawsuit
No,
for
all right, we'll not comment on that. That the learned single judge will decide.
lawsuit. That's what I'm pointing on lawsuit. The issue is still open before the other single bench, which lawsuit the other single bench can decide.
All right, yes, that's all, Mr. Tapi.
Lawsuit.
Yes,
And,
Mr. Dekar.
and just a small, Alice come to my epidemic.
Yes,
On lawsuit, turnover lawsuit, issue of turnover lawsuit, just for information clarification lawsuit. Kindly come to para 5 of my epidemic.
which is page number.
This is page 5. My page 5. Paragraph 5.
This is affidavit filed by 3, 4 and 3,
Correct.
4, 5 and 6.
Correct.
Okay,
Lawsuit.
which page you are referring to?
Para 5.
Yes.
Para 5. Just allow to read.
Mhm.
With regards to the statement made in paragraph 3 of the writ appeal, the answering respondent state that the statement of appellant on the requirement of average annual turnover under clause 4 and so of the RFP is wrongly interpreted and misleading. Actually, it reads the bidder should have had average annual financial turnover gross of not less than 158.50 crore on any works contract during the last 5 years. Balance sheet duly audited by chartered accountant. RFP 7. On any works mean not only on similar works, but on any works executed by the bidder during the last 5 years. Any works means not these similar works. Any works executed by the bidders during the last 5 years. Average is when average is taken more when more.
So respond number 8, 9 and their bids are
4% losing. Not the private.
Those who are declared responsive. Respondent number 7, 8, 9, 10.
There
These
are another
persons,
more
8,
than
9, 10.
5 bidders over there. Another 4% bids were rejected on this ground.
so petition appellant plus
Including the petitioner.
including the appellant 4.
4. And kindly come to
Yes. Yes. Can you give the appearance slip, who is appearing for him? Appearance slip.
kindly come to page.
Appearance slip. Who is appearing for yes.
Kindly come to page 33 laws. On this clarification laws. This is laws extract from SOP, the CPW manual laws.
Page 33 of
Page 33 of my affidavit. This is 7.0 and I'm taking laws to 7.2 laws.
yes.
The bidder the bidder should have had average annual financial turnover of so and so on civil or electrical construction work during the last 3 years. Here lordship 5 years as per balance sheet duly so and so. Year in which no turnover is shown would also be considered for working out the average loss. That means lordship the 5 years loss.
You are referring to page 33, clause 7.2.
2 loss. While taking out the average losses, even if for a particular year work has not been executed also losses, that would be taken into consideration losses.
What is this document?
Losses.
This is the instruction to bidder.
This is the extract losses from SOP, TPW manual loss.
The centrally sponsored scheme, so PWD manual.
Yes, respondent number 7.
I'm obliged, my lord.
Dekha, what do you have to say?
My lord, lordship has expressed lordship's mind that lordship is not staying the work. Let all the issues be decided by the honorable single judge, my lord. Let
Yes.
everything be left. Let everything be left open, my lord.
All right.
On the merits, my lord, will address the honorable single judge
Yes. All
because this is an appeal against the interim order. My lord. Obliged.
right. Have you filed your affidavit in the writ petition?
Not in the writ petition, my lord. Lordship will give me, since lordship is fixing up on 22nd of April, my lord. Within a week's time, we'll file our response.
Yes. Mr. Tapin, you also filed your
They,
counter affidavit?
whoever the files.
And government has filed in the writ petition.
Government has filed in the writ petition.
Government means respondent numbers 1 to
Yes.
1 to 5.
For file.
1 to 5.
Yes.
1 to 6, my lord.
1 to 6. And 8, 9, and 10 will delay. That prayer you make for the single judge. Disposed of. To get the order later.
Obliged.
Problem.
Yes.
May I please, your lordship, a new legal aid counsel was appointed in this matter, your lordship.
Mhm.
She seems to be absent today, your lordship. Since the paper, we have also received the paper book, your lordship. However, since the accused was convicted under section 6 of POCSO Act, your lordship, it's
To mention item number 17 and 18, Lordship.
17 and 18.
Lordship. Lordship, in this matter, Lordship, the pleadings are completed, Lordship.
Mhm.
And I have obtained the consent from all the parties, Lordship. So this matter may be taken up next week, Lordship, for the final, for the admission hearing, Lordship.
If your lordship see, Mala, there will be a by order, Mala. Actually, I mentioned last week, Mala, for a listing of this case. My brother, he works of accommodation, but it's okay, Mala. No, but these are for orders. Why you want it to be?
Lordship, since the pleadings are.
Let it come up, then we'll pass an order.
Right.
We are going somewhere. Be here for another half an hour. We'll
Lots.
take up these matters.
Leave, Lordship.
Yes. Yes.
Your Lordship, I beg to mention item number 12. Your Lordship, leading counsel for petitioner Adam Tata is not present today on medical ground. Your Lordship, I pray for agent for today. And I kindly pray for matter fix after 3 weeks.
Your Lordship, I for respondent number 3.
No objection.
No objection, but date may be given, Lordship, our station.
After 3 weeks, give a date. Mr.
Monday.
Dejum Tali.
Huh?
Dejum Tali.
So and so, appearing for the petitioner's 6 adjournment in this matter on the ground that the arguing counsel, Mr. Adam Take, is indisposed due to medical reasons. He prays for posting this case again after 3 weeks. The learned GA AP Miss so and
As
Mr.
Dev.
Is there learned counsel for the respondent number 3? Do not have any objection to the prayer, but 6 posting of this matter on give a date after 3 weeks.
Monday, April. 8th of April.
12th of April.
12th.
Prayer allowed.
So
list
8th,
accordingly.
I'd asked for 8th of April.
Yes.
All right.
So can it be in the latter part of April? I'll be back in on 15th of
15th
Give
of
a date,
after. Keep it at one.
24th of April. Yes,
Yes, Lordship.
yes,
24th.
24th.
all right.
Much obliged.
Yes.
Item number 1.
Wait,
Yes.
my lord, the petitioners are, my lord, the outgoing chairman and members of the Arunachal Pradesh Food Commission.
Hmm.
My lord, in the rules framed under the National Food Security Act, there is a provision for reappointment for 1 year.
Hmm.
Though the word is used 1 year or reappointment, but it is only for a period of 1 year. So our proposal was sent by the member secretary for the extension, my lord. Nothing was done, no consideration, they have not advertised. That is our grievance. At least consider our proposal first, then
Where is the proposal sent by member secretary?
proposal is at my lord.
Page,
Page 63, my lord. Type copy is at page 64. This is by the member secretary to the secretary. I am to state that as per state gazette such and such, the tenure of AP Food Commission is for 5 years, which comes to an end in the first week of March. However, as per section 4.2 of the notification, the chairman and the members are eligible for reappointment for another period of 1 year till first week of March 2025, which may be considered favorably. So this was sent, my lord.
Hmm.
So
so the
nothing,
term has already expired.
yes, now it is.
So eligible, this is only eligible.
Yes, ma'am.
This provision only says your clients are eligible,
Yes,
not that they are.
yes, that is there. Ma'am. What only I'm praying for, the advertisement has now been issued. If your lordship may direct, they may consider it either this way or that way, madam, since this was processed.
You have a very weak case.
It appears so. That is the only prayer I'm praying for, at least some sort of consideration. ma'am.
My lord, since rules that does not provide for extension, my lord.
Hmm.
It says that they will be eligible for reappointment until and unless they apply. It is not a matter of extension. My lord will kindly see page 36, the rules
Page
of the
36.
act.
So you apply for reappointment then? It is reappointment, not
Yes, ma'am.
extension.
Not extension, my lord. Page 36, 16, section 16, clause 4, my
Yes.
That I've understood, ma'am, that is there.
chairperson and every member of every other member shall hold office for a term not exceeding, my lord, 5 years, not exceeding 5 years from the date of.
It is,
So you apply as per the advertisement, you will
That
be
I can
entitled to
do.
reappointment, that's all.
but my lord, it was the understanding of the competent authorities also that though the word reappointment is there, it is an extension. If your lordship may kindly have page
We can't
59,
go by these understandings, we'll have to go by the statute.
that is there.
The statute says you will be eligible for reappointment. That means you can again become for 5 years.
Yeah.
You can again become the chairperson.
Only for 1 year, because the parent act says 5 years, my lord. That I could have understood. But since they have cut it down only to 1 year, my lord.
No,
though
but
the
where
word
is 1
reappointment
year?
is used.
16.4 doesn't say 1 year.
My lord,
16.4 is 5 years, that is the parent act. But the rules framed under section 40 of the parent act,
Hmm.
it provides for only 1 year, my
Where
lord. That
the
is
ru-
why.
where are the rules?
At page 50, my lord, the rules.
Page 51, it starts from 49. Rule 4, my lord, rule 4.2.
Page 50.
A person who held the office of the chairperson or member shall be eligible for reappointment, but the reappointment shall hold office for a period not exceeding 1 year. That is why, my lord, I am submitting, my lord, though the word reappointment is used. In terms of the rules framed by the state, it appears to be an extension, my lord. Because earlier, my lord, in terms of the rules, it was only for 3 years. There was not in consonance with the act. Down director rectified it.
But that's all right, whether it's for 5 years or for 1 year,
Madam.
reappointment cannot happen unless you apply. It's not extension.
Yes.
That you agree.
Yes, I-
Then you apply for reappointment.
along with others.
Huh?
Yes.
That will not say. He says that if they apply for reappointment, it will be considered in the
My,
budget.
my lord, that was,
Apply.
that was.
We'll close it then.
Yes.
Heard Mr. D. Pang, learned counsel appearing for the writ petitioners, also heard Mr. M. Ratan. Learned additional AG AP appearing for the official respondents. The three writ petitioners hearing were earlier appointed as chairpersons of the Arunachal Pradesh State Food Commission wide order dated 01/02/2019
Right.
for a period of 5 years. Full stop. The term in office of the three petitioners came to an end on 01/03/2024. Full stop. Thereafter, the secretary to the Food and Civil Supplies Department when did the advertisement come out?
Advertisement, my lord, was on 2nd of March, 2024. At page 9, type copy, or page 72, type copies at page 73.
Issued an advertisement dated 02/03/2024 inviting applications for appointment in the vacant post of chairman, in the vacant post of chairperson. Actually, petitioner number 1 was the chairperson and the other 2 as members. You have to write it like this. We read in the beginning where I said, you just change it. The read petitioner number 1 was appointed as chairperson and the petitioner numbers 2 and 3 were appointed as members
Yes.
of the Arunachal Pradesh State Food Commission wide order dated 01/02/2019 issued by the secretary.
0103, my lord.
Original appointment was 01/03.
My,
There is a mistake in your synopsis.
oh, my lord, I'm sorry.
01/03/2019 issued by the secretary to the government of Arunachal Pradesh Food and Civil Supplies Department. Full stop. Their term in office was for a period of 5 years with effect from the date of appointment, and accordingly, the same came to an end on 29 29/2/2024. Full stop. The member secretary of the commission had in the meantime forwarded a communication to the government dated 02/02/2024 recommending reappointment of the petitioners as chairperson and members of the commission for a further period of 1 year.
Right.
In deference to the provision of Rule 4 bracket numerical 2 of the Arunachal Pradesh State Food Commission Rules 2018. However, the said recommendation was not considered by the government and instead advertisement notice dated 02/03/2024 has been floated inviting applications for filling up the vacant posts of chairperson bracket 1 and members bracket 2 in the Arunachal Pradesh State Food Commission. Stop. contending that the writ petitioners were eligible for extension for a further period of 1 year. And therefore, the government ought to have considered the recommendation dated 02/02/2024 made by the member secretary favorably, they have approached this court by filing the instant writ petition seeking a writ of mandamus, full stop. Next, responding to the grievance expressed in the writ petition, Mr. Ratan, learned AAG AP, has invited the attention of this court to the provisions of section 16 bracket 4 numerical 4 of the National Food Security Act, 2013, as well as the provisions of Rule 4 bracket 2 of the rules of 2018 to submit that the provision prescribes reappointment of the chairperson stroke member as the case may be, and therefore unless as the case may be, and not for extension of tenure in office, and therefore unless proper application is submitted by the candidate seeking reappointment, such prayer cannot be considered under the rules. Full stop. Mr. Pangi, learned counsel for the petitioners, has also fairly agreed to the state submission that it is not a case of extension, but reappointment, within course reappointment. Hence, full stop. Hence, it would be necessary for the petitioners to submit appropriate application seeking reappointment. Full stop. In view of the above consensus reached at the bar, without making any further comment on the merit of the claim, this writ petition stands disposed of. Writ petition stands disposed of by granting a week's time to the petitioners to submit appropriate application seeking reappointment on the posts claimed by them. If such application is submitted within 7 days, if such applications are submitted within 7 days from today, the same be considered and processed as per the provisions of the Act and the rule and brought to its logical conclusion.
Madam.
With the above observation, the writ petition stands disposed of.
Obliged.
Item number 2.
May I please vote? May I please vote? My lord, I'm challenging the legality of NIT dated 4th of March 2022, which is at page 17. My lord, my ground for challenge this NIT is it was issued in violation of clause 4.11 of the CPWD Works Manual 2022, madam, which is at page 20, madam.
So you are an intending tenderer.
Yes, ma'am, I'm a registered conductor of that area, madam. Registered,
You have participated in the NIT.
no, madam. My lord, since, no, madam, I have not participated. I'm challenging the NIT itself, madam.
Why?
Because, my lord, this NIT has been issued madam, in violation of, my lord, this clause 4.11 of CPWD manual, madam. Because there is no any technical center.
No, but you are not a participant in the NIT, then why, it's a PIL?
No, man. My lord, in my humble submission, madam, even if I participate in this NIT, my lord, and even if my lord, I have been, my lord, awarded a contract, my lord, I will be at the disposal of the respondent authority because there is no any technical sanction, my lord. Neither there is administrative appeal.
These
no
are
procedure.
matters to be decided, to be looked into by the CAG, Comptroller and Auditor General. You can't come and file writ petition and say, you want a stay order, right?
My lord.
That's not possible.
My lord,
There is a complete kind of confusion in these matters. If they do not follow the proper financial procedure while floating the tender, this will invite consequences under the CAG's direction, not the court, or not a tenderer or a contractor. You can come to the court if your right is violated, not for setting right the way of functioning of the department. That's not your job.
That's I understood, my lord. But I know the authority cannot do a thing, my lord, which they are not authorized to do, my lord.
No, you may be correct.
Well-
Your allegation may be correct, not on that. This is not the forum to look into all these things. Every answer is not there in the court proceeding. There are different authorities, Comptroller and Auditor General is there, who will look into the procedure, whether the financial norms have been adhered to or not. There are other agencies, CVC is there. Those things will come into play. But you cannot suddenly come and say that, all right, according to me, they have violated, so issue notice and hear the matter. This is not the job of the court. We are here to protect the rights of the citizens,
Yes, ma'am.
not to go on a wild goose chase. There could be hundreds of other work they have done without following the norms. And you may be right that these things require attention, but this is not the forum.
My lord,
What do you have to say on that?
in
And
that
another
case,
problem is we have not included the CAG as a party.
CAG is
Even
not
if,
part.
even if your allegations are correct,
No.
even then, the CAG will have to say, the Principal Accounting General will have to say whether this was done by following the financial norms,
My lord,
administrative sanction or not.
there is one RTI, my lord, information, my lord, where it has been, my lord, reflected that this administrative approval and expired decisions have not
Then
been
the
by
government
court.
will face the music. Why are you bothered? If the department has issued a NIT without the administrative approval, the government will face the music. Why are you bothered about it?
My lord, in my humble submission, my lord, whether that's not amount to misrepresentation by the.
No, your humble submission, I have understood. In the humble response of the court, this is what I have to say.
My lord, in that case, my lord,
Like this,
my lord, in that case, my lord,
what do you want? Stay order.
yes, my lord. Yes, my lord, my lord, otherwise
You
there
will
is,
be happy if there is a stay order. The work should be stalled.
no, my lord.
Then,
My prayer is, my lord, let this NIT, my lord, set aside, my lord, and press NIT said because
Fresh
what
NIT.
after obtaining, my lord,
then
this
you will participate.
definitely, my lord, I will participate.
This you cancel, issue fresh, then he will come and participate, then you proceed.
My lord,
What is your
that-
response?
that is my prayer, my lord.
That is your prayer.
Yes.
He is understood, he is laughing. He is understood. What do you have to say?
Lordship, this is the obtaining approval only say this is the discussion of that authority only.
Hmm.
He cannot dictate us, the petitioner cannot dictate the government, you should do this and you should that. If there is something is there, he can, it's your lordship has rightly pointed out. He can
But
process.
is it not required that proper administrative approval should be taken before the
Yes.
work is, NIT is issued?
As for their RT, this is
All right, notice has not been issued, we'll issue notice.
Yes.
You file your affidavit, then we'll consider. You are Mr.
H. Lampu.
Mr. H. Lampul and counsel for the petitioner is present. Mr.
Airam,
Leonard, you are the standing counsel,
additional senior.
additional. You have to put it in face, huh? Has appeared for the official respondents. The basic allegation in this writ petition is to the effect that the respondent numbers 1, 2, and 3 have Who has issued the NIT?
My lord, executive engineer, my lord.
The respondent
PWD.
number-
Respondent number, my lord, 3, my lord.
The respondent number 3 has issued the NIT dated 4/3/2024 without obtaining administrative approval and expenditure sanction from the competent authority. First up, the petitioner claims to be in receipt of information in this regard through the reply furnished to him under the RTI Act 2005. First up. Mr. Lampu has also prayed for an interim order suspending further process on the of the NIT. First up. The grievance raised in the writ petition will have to be addressed by the department authorities by filing affidavit. First up, the prayer for interim order can be considered only after the affidavit is brought on record by the departmental authority. As such, issue notice of motion returnable on 24th of April 2024. Since Mr. Swansea appeared in accepted notice on behalf of respondent numbers
1 to 3, my lord.
1, 2, and 3, no formal notice is required to be sent to the said respondents. Extra copies of the writ will be furnished to Mr. Swansea so as to enable him to obtain instruction and file affidavit. Petitioner to take steps for service and notice upon respondent numbers 4 to 8 by registered post with AD within 3 days from today. Full stop. Third, on the prayer of interim relief, this said relief will be considered on the returnable date. The official respondents to positively file affidavit on or before 22/4/2024 by serving advance copy upon Mr. Lampu.
Obliged.
Item number 3.
May I please your lordship? Lordship, the petitioner is the owner of Taiwan Enterprise and he brought a vehicle bearing registration number AH01M.
You don't have a state
No,
commission?
no.
Lordship, no, as of now, no, Lordship. So there is a similar matter, Lordship, pending here, Lordship. So in that matter, we have already filed affidavit also. That may be, Lordship.
Similar
Just
matter.
together, similar for the sitting of the president, commission, Lordship. It is, Lordship, this was advertised also, but then because, Lordship, there was no candidate, only one candidate came, but then it was also, Lordship, Lordship.
Yes, Mr. Rattan, you want to say?
There is a difficulty in appointment of the chairman.
Chairman.
There are many advertisement has been issued, but none is coming forward, my lord.
Okay.
And there is a change in the criteria for appointment also.
What is the criteria now?
Criteria as per the Supreme Court's ruling, my lord, there has to be a interview also.
But the latest,
There are litigations, my lord. Seeking change of that direction also.
All right, what is the? what is the
Lordship,
case
I'll
number?
give you the, Lordship, in that one, we have filed already. Let us,
What
position
is the
is
case?
that affidavit, Lordship.
Case number?
WPC 326 AP of 2023.
326 AP of
2023, Lordship.
326.
AP of 2023, Lordship.
So we'll take
MS
the
Cost
matters-
Brothers. This may be listed together. In that we have filed.
Yes,
already.
Mr. Phukan.
Lordship, in the meantime, kindly stay the order dated passed by the learned district commissioner, Lordships.
Your claim has been rejected.
Yes, Lordship.
What is there to state?
Lordship, until and unless the state commission will form.
You have not applied your mind.
Yes, Lordship.
Your claim has been dismissed.
Yes, Lordship.
What is there to stay? If it is stayed, then it will become allowed.
Yes.
No, Lordship, not such. Until and unless the form will form, state form will form.
Your claim was for insurance of a vehicle, which was washed off.
Yes,
The insurance company, New India Assurance Company, said, sorry, you have not complied
eligible
with
for
the-"
claim.
Yes.
Yes.
So the claim is rejected. Against that, you preferred appeal State forum not available.
Not
you
available.
went to the national forum.
Yes,
National forum says we can't entertain it.
Yes.
You are before the court.
yes,
You want adjudication of your appeal,
yes, Lordship.
correct? What is there to stay?
Nothing.
Nothing, Lordship. No, Lordship, until and unless the form will, state form will form, then stay may be allowed to me, Lordship.
Stay of what?
It does not mean for execution, Lordship.
Please apply your mind. Your petition has been dismissed. You want the stay of the order of dismissal.
Yes. They have to tie up with along with WPC number.
No, you still want a stay or you don't want?
Actually, I need to stay, Lordship.
Stay of the order of dismissal.
Yes, Lordship.
Then it will amount to allowing the appeal, is it?
Yes, Lordship.
I had Mr. G. Fukan, counsel for the petitioner. The what's your name is G. Leonard. Your government advocate APP.
Yes,
right?
additional senior comment.
Additional senior government advocate APP.
Representing
The
Lordship,
respondent numbers
1 and 2 Lordship, 1 and 2 Lordship,
1 and 2.
1, 2 and 3.
1, 2 and 4.
Yes, 4 Lordship, 3, I will not.
The complaint filed by the writ petitioner before the Consumer Dispute Redressal Commission, Papumpare, alleging deficiency of service against the respondent number 3 came to be rejected on
36, 2020,
36, 2023.
23rd.
Full stop. Although an appeal lies against the order, yet due to non-availability of the State Consumer Forum in Arunachal Pradesh, the writ petitioner could not pursue the appellate remedy. Full stop. Although it had approached the National Consumer Forum seeking redressal of its grievances, yet no relief was granted to the petitioner on the ground that the same was technically not permissible. National Consumer Dispute Redressal Commission, National Consumer Redressal Commission, New Delhi. Yet by order dated 25/1/2024, relief was declined to the writ petitioner on the ground that the same was not technically permissible. Situated thus, the petitioner is before this court by filing this writ petition. Stop. Ms. G. Ete, learned additional senior government advocate AP, submits that a similar writ petition raising similar point pertaining to non-availability of the appellate forum in Arunachal Pradesh is pending before this court in the form of WPC 326 AP oblique 2023, wherein the state has already filed affidavit.
Yes.
And therefore, this matter be tagged along with the aforesaid writ petition. In view of the above and considering the nature of issue involved in this proceeding, this court is of the opinion that the matter calls for further examination. Stop. Issue notice returnable on 26/2023. Since the respondent numbers 1, 2, and 4 are already represented by the learned government advocate, no formal notice is required to be sent to the said respondents. However, extra copies of the writ petition be furnished to Ms. Ete within 3 days from today. Petitioner to take steps for service of notice upon respondent number 3 by registered post with AD. Registry to list this matter along with WPC number 326/AP/oblique 2023. Again on 26/4/2024. Right? Prayer for interim relief will be considered on the returnable date.
Oblige.
Item number 4.
Madam, petitioners are aggrieved by non-payment of compensation against their community lands, which have been used by the Border Roads Organization as dumping zones for construction of a bypass road. Madam.
Yes, why aren't you paying them compensation, Mr. Ratan?
This will be appropriate authority to answer will be the union government, my lord.
Yes.
My lord, this is my president, my lord, I may be allowed to take instruction. My lord, there must be something, my lord, why, my lord, yes, notice may be issued.
All right. Heard Mr. R.L. Thungan, yes, learned counsel appearing for the writ petitioner. Aggrieved due to non-payment of just compensation for using the petitioner's land as dumping ground. The instant writ petition has been filed seeking a writ of mandamus for payment of compensation. Petitioners, petitioners. It is proven petitioners, when petitioners land there after S apostrophe S. Mr. N. Ratan, learned additional AG, State of AP, has appeared for the respondent number 1, whereas Mr. M. Katu, learned GS,
DSCM, Deputy Solicitor.
Deputy Solicitor General of India, has appeared for respondent numbers
4, 5, 6,
Mr.
and
Ratan
7.
for 1 to 3 and Mr. M. Kato for respondent numbers 4 to 7 and have both prayed for some time to obtain instruction and to file affidavit. In view of the above, issue notice of motion returnable in 4 weeks. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned standing council, learned departmental council, so as to enable them to obtain instruction.
Item number 28.
Well, there is a caveat also. I have informed the caveat at council. He says he is not,
We'll take it up at 2.
at 2, my lord.
Item number 5 and 6.
Please, Madam. I'm applying for respondent 3 and 5 and petition for this. I'm the petitioner in item number 6.
So this matter has to go for arbitration.
My lord.
My lord, why is I am challenging the impugned order passed by the Secretary Housing in item 5.
My lord, may I?
Just one by one, please. You are for the writ petitioner.
Yes, in 5 I am for the writ.
And you are for the petitioner. in
I am
five?
for respondent 3, my lord, in item number 5, my lord.
He is respondent number 3. In item 5. Page 90, that is impugned order. So when the secretary transfer the land in question in their favor, department. So Secretary Housing is not a competent authority to transfer any land.
So that you have already filed a suit, civil suit. Civil suit is already pending.
I have filed civil suit with another person, another group. So I have the civil suits in my favor.
So you have a decree in your favor.
Yes, in
What
civil
is the
suit.
decree?
Or decree, I have not. Decree, civil suit was in against some other person, not the department.
But pertaining to the same land.
Same land. My lord, crux of the case, the fact of the case is that there was MOU between the respondent number 3 company and me. I am the landowner.
So they have entered into MOU to construct mass affordable housing complex. So there is terms and condition in the MOU. So if there is any violations, any dispute between the respondent number 3 and petitioner has to be settled between the government have nothing to do. So they are not a party to the MOU between us 2010. And there is another MOU between the respondent number 3 and the state urban respondent authority. They have MOU. MOU is in regarding 3-4 plot of lands, not my lands only. In my plot of land, they have constructed some incomplete structure in between the company Plidabet. Plidabet from they abandoned the project. Then so many 300-400 people, they try to occupy that land. Then there was a police case. Then I have to file a title suit against these peoples. They abandoned the project. Then government they have booked some plate from the buyers. So they have to return the money to the buyers since project was not success. Then there was direction from the Honorable Court. In order to repay the amount. Now what the respondent number 3 and the government do. They said that half constructed area will taken away by them. They will sell that land and they will replace the money which the government have paid to the intended buyers. Now, while doing that, they have never informed the landowner.
So what is the relief you are praying for?
My prayer is that to discuss this impugned order where they have transferred the land in favor of the housing department without my knowledge. That is page 90.
So land belongs to you?
Yes, land belongs
Where is the
to
proof?
Yes, I have a LPC. This
Who is appearing for the housing department?
Mr. Pratim Tapo is out of station, I am told. This page 19 series, annexers 1
No one
series.
appearing for the housing department. Ms. Ette, this is a government department, nobody is appearing.
This UD, they have a standard person.
Pratim Tapo, he is out of station.
But he must be having a junior.
Yes,
UD.
Without him, how do we proceed in the matter?
that is there.
My lord, the previous order dated 22nd January, that was loud and clear, my lord, that everybody was to present because earlier it was 2-3 adjournments already in this matter to finally for the adjudication, my lord. So kindly have a look of.
And your matter is appointment of an arbitrator.
My lord,
His matter is arbitrary.
was the matter, my lord, let him finish, my then I'll come into my lord, then I'll
No,
clear
what
that.
is there to finish? We can't decide this matter.
My lord, I'll just, my lord, if he's completing his submission, my lord will hear my submission, then definitely. My
No,
lord,
no, are you a party in this WPC 80 of?
yes, of course, my lord, I'm responding to 3, my lord.
You respond number 3.
Yes, my lord.
So you want this matter to be decided in
My lord,
absence
my
of-
lord, my lord, because
We
all.
will not do it. We will not do it. You might, but we will not do it. Where is the council? Nobody is there.
No, I don't want anyone here. I'll make a call and see.
No, then where is Mr. Ratan, the additional AG?
He's also.
Everybody has.
My lord, may I please see my lord, order dated 22nd of January, my lord, the previous order.
Yes,
Yes, my lord.
yes, what do you want to show?
Yes, my lord. This is the order passed by this honorable court, my lord, after previous 2 adjournments. So, my lord, this is the order of this honorable court, that the last line, my lord. That is further clear that in this case, same situation persists, this court would make an endeavor to pass the appropriate order in both the matters, my lord. Because both the matters, my lord, are actually interconnected, my lord. In both the matters, my lord, there are arbitration clause, my lord. So in the writ,
So you are outstation counsel.
my lord, I am Abhinav Prakash, my lord. I am the outstanding counsel, my lord, in this matter. I am representing respondent 3 in item number 5, my lord, and the petitioner in item number 6.
You have to stay here tonight. We'll take up the matter tomorrow and dispose it of both.
My lord, I have, because my flight at 3 o'clock, so I have no issues.
That
If
we can't help. Then we'll adjourn it. I will not dispose of this matter in the absence of the council. Yes.
Pardon
Where
me,
is the council?
Your Lordship, I'm appearing on behalf of leading counsel, Pitafo, standing counsel,
Yes.
Union Housing. Your Lordship, Mr. Tafo is out of station, Your Lordship.
Maybe, but there is an order of the court. It will be taken up today.
In that case, Your Lordship, let them argue, and on the next date, let the standing counsel be argue.
Today is the last day. If you are agreeable, I can take it up tomorrow. Otherwise.
tomorrow, my lord, that pages are top of the board, my lord, that will be very convenient, my lord. My humble submission, my lord. I'll just.
No, you see, we are accommodative to councils coming from outstation, but don't stretch it too far.
No, my lord. I have never actually, my lord, requested such kind of actually requested.
You just made it 30 seconds back. How can this matter be taken top of the board?
My lord, because just humble submission, my lord, because ultimately, my lord, this adjournment, I'm
Listen,
not party to this.
We'll
adjournment.
take up the matter, both these cases tomorrow. You better come prepared. Otherwise, we'll decide it expertly and we'll pass an order in such a manner that you can't prefer a review. Tomorrow.
Tomorrow, my lord, if I have no problem, my lord, because no problem, my lord. Tomorrow,
Tomorrow.
In that case, Your Lordship, day after tomorrow, if permits.
He can submit through BC also.
but that option was available to the standing council Suda also, my lord.
No, what do you want? Tell me.
My lord, I am ready to argue, my lord, today or tomorrow morning, my lord. I have no problem. I'm here to argue.
Then you come prepared tomorrow. We take up the matter.
In my case, my lord, my prayer suffice the way they have filed arbitration. There is arbitration clause. So without arbitration, follow the terms and conditions, they cannot transfer
The
the land.
arbitrator cannot decide the validity of the order passed by the housing board.
Yeah.
Taking over your land. That
Yeah.
cannot be decided by arbitrator.
My lord, in this matter, my lord, the audacity of the petitioner is that first of all, they entered into an agreement with respondent number 3, my lord, the joint venture agreement, my lord, for 45 acres. And they never had the possession of those 45 acres. They never was the owner of that 45 acre of land, my lord. They had transferred 9.12 acre, my lord. Kindly have the prayer paragraph of this writ petition, my lord. That will be very clear.
All right, heard Mr. So-and-so for the writ petitioner. Also heard Mr.
Abhinav Prakash. Abhinav Prakash.
Abhinav Prakash, learned counsel for the respondent number 3, who is representing the petitioner in item number 6. We give the case number. None has appeared for the Housing Department of Government of Arunachal Pradesh, despite the order dated 22/1/2022 passed by the Senate of the earlier occasion, clarifying that no further time will be granted. No further opportunity will be granted to the departmental council on the next date, that is today. First of all, in view of the earlier order, this court, no, you're right. Today also, the learned counsel for the respondent number 2 is not present, and a submission has been made by his junior, Mr.
E. Menjo, Your Lordship.
You?
E. Menjo.
Put the name. That is senior, Mr. T. Tapin.
P. Tafo, Your Lordship.
P. Tafo.
Yes.
Is out of station. In view of the order dated 22/1/2024, the said prayer made by the departmental council is liable to be rejected. However, considering the nature of controversy involved in this proceeding and the fact that an outstation council has come in this case to argue the matter, this writ petition along with the arbitration petition is directed to be listed tomorrow, that is, give the date again as fixed item in the top of the column of admission hearing. The respond number two to make alternative arrangement, failing which the matter will proceed as per records list accordingly.
Published.
Item number 7.
I am appearing on behalf of respondent number 1, 2, and 3. Indian Oil Corporation. Matter relates to my lord reconstitution of my lord leadership. And there is a stay order in operation, my lord.
But where is the petitioner's counsel? Who is appearing for the petitioner?
My lord Rintu Soikia, Digam Nasi.
Where is Mr. Rintu Saikia?
I have not seen him. There are other counsel also, my lord.
He is not visible. We have also not seen him. Then we'll dismiss the matter. Can you wait till 2? We'll dismiss this for default if he doesn't, nobody turns up. Can you send an information? Or should it be posted on some other day?
If possible, my lord, Lordship may fix it up to, if my lord, he comes in the meantime, my lord. Or there are some other councils also along with him.
All right, call it 2.
Item number 8.
May it please your lordships. My lords, I am appearing for the petitioner in item number 8, 9, 10, and 11.
Yes.
My lords, the application is for appointment of an independent and impartial arbitrator. My lords, the pleadings in this matter has already been completed, and the only issue in the matter is regarding the escalation, which, my lords, is on merits and has to be decided by the arbitrator. So, my lords, may kindly appoint anybody as an independent and impartial arbitrator. It might be a technical person, my lords. We have already mentioned in para number 21 of our petition, there are a few names which had to be agreed by the opposite counsel. So, we are just waiting for his consent.
My lord, basically, department is raising on 2 contentions, my lord. The first is admittedly, my lord, that will be decided by the sole arbitrator, my lord. And the second contention is, my lord, regarding the appointment of the arbitrators, though, of course, my lord, there is a clause for the appointment of the, my lord, sole arbitrator can be appointed from the serving, my lord, the officer, my lord, of the department.
No. Please place your case, madam.
My lord.
This is your case.
So therefore, my lord, may I take your lordships to the arbitration clause? Where is, my lord, the specific paragraph?
Where is the arbitration clause?
My lord, arbitration petition number 1, my lord, page number 80, clause 70, my lord. 80, clause 70, my lord. Page 80, clause 70, may I read, my lord?
Yes.
All disputes between the parties to the contract, other than those of which the arbitration of the commander contract or any other person is the contract expressed to be final and binding, shall, after written notice by either party to the contract to the other of them, be referred to the sole arbitrators of an serving officer having degree in engineering or the equivalence, or
the past final oblique direct, the final examination of that subdivision 2 of institutions of survey here, India, recognized by the government of India to be, madam. So therefore, madam, basically it has to be appointed from the, madam, the serving officers of the, madam, the department. And now,
My
madam,
lord,
for
that
that,
cannot, my lord, my only submission is that is barred by law now. As per the new Arbitration and Conciliation Act, a serving officer cannot be appointed as an arbitrator, and that is our sole submission here, that an independent arbitrator may be appointed.
I don't know where, you please argue your case. You are not arguing. You are only saying this is for appointment of arbitrator, appoint an arbitrator. That kind of argument I cannot pass in order. What is your case? I have to be satisfied that there is an arbitrable dispute, etc. You are not arguing anything.
My lords, the arbitration clause is clause 70, which was rightly pointed out. But I'll just read it again with my lords.
Yes.
All disputes.
There is no one appearing here. There is no local counsel here.
My name is reflected into course list because I have been.
But you are sitting in the
Lost.
gallery. Yes.
Sorry.
Yes. What is it?
My lords, all disputes between the parties to the contract, other than those for which the decision of the commander contract or any other person.
Right. So this is the arbitration clause. Now, where is the
arbitration
letter demanding arbitration? Where is it?
My lords, I'll just take my lords through that. My lords, it is annexure 9.
No, where
This
is
is
annexure
letter-
9?
This is letter dated 23/1/20.
Where is annexure 9? Where does one find it?
My lords, the page numbering is not complete in my paper book.
Then let's, we can't take up this matter like this. You give me the page number, etc. The page number is not telling.
My lords, the page number is not complete in my paper book.
it is 121. $121.
Why there are five cases, 5 petitions?
Plus
There
they're
are a number of
Different contract work, man.
these are different
contract work.
contracts.
Altogether, 4 packages.
So facts are same, only the contract
Almost same,
numbers
madam.
are different.
Almost same.
Where is the list of contract numbers and amounts?
Lordship, that, I'm sorry, Lordship, the briefing I forgot to bring it.
Then it is not possible to pass orders. We cannot go through
My
the
lords,
file.
my lords may kindly keep it for tomorrow. I will just check with the local council and get my file on place. My lords may kindly keep it for tomorrow. It is my humble request.
We'll take it up day after tomorrow then.
Lordship.
You give a chart of contract number, in which case, what is the amount due? What is the name of the work? Because the order will be more or less common, is it? Day after
My lord, it
tomorrow.
will be exactly the same. This
No,
this
no,
has to
you
be.
give us these facts and figures.
My lords, may keep
Without
it up,
that-
keep it for day after tomorrow. We will give you the
Day after
entire
tomorrow.
figures.
On the request of learned counsel for the petitioner, petitioner in these cases, who has addressed this court through remote video conference. These matters are directed to be listed again day after tomorrow, that is, give the date. Mr. M. Katul, learned counsel, is present on behalf of the, learned DSGA is present on behalf of the respondent.
All respondents. Deeply obliged.
Please prepare,
Obliged.
you also prepare
My
a
lord.
list. What is the dispute? Then when was arbitration demanded? Then now there is a change in the clause. So a departmental official cannot be an arbitrator now. So then there is a panel of arbitrators.
Yes, madam.
You, both of you have the panel. Can you agree on a name? If the matter has to be sent to arbitration.
Madam.
And the maintainability you raise before the arbitrator.
Exactly.
Is
My
it
lords,
not?
we will prepare a chart.
Madam.
That's all. Only
Yes,
if
madam.
there is an arbitrable dispute, the matter has to go to arbitration.
Yes, madam.
That's all. And they have demanded arbitration, you have not responded, so now you can't exercise your option.
My lord, he has agreed to that contract, wherein my lord, specific provision is given, lordship has already seen. By virtue of that clause 70, my lord, agreement has to be made, so as to make reference to the arbitrators for appointment event, my lord. He has to give consent for appointment of the arbitrators, my lord. That is the clause, my lord.
No, but that is your departmental person.
Yes, madam. And department has time and again written a letters to him, reply to the letters which lordship has already seen. And in
Just ask them. They'll
My lord.
ask you the truth.
My lord.
This will be item numbers 8 to
11.
8 to
11, my lord.
8 to 11. Same order.
Deeply obliged.
Deeply obliged.
Obliged.
Item number 13 and 14.
Well, the case in nutshell is the petitioner is a headmaster. He was put under suspension on 2010-2022, my lord. Then he was released on bail on 10th January 2023.
These are covered matters.
My lord, that Ajit, my lord's judgment.
The covered matter, Ajit Sanwal.
Yeah, I have brought him, my lord.
My lord, admittedly, madam, no review.
No review, my lord. That's fact. Well, I was going through his order by my lord only. Excuse me, brother. Take me, lord, please. Para 13, my lord. 12:30.
Party non-movable. Allowed.
My lord. Grateful. My lord, that's item same, but it is a UDC.
Item number 15.
The lordship, the facts and issues in this matter are analogous to item 19. It may be taken up with 19.
Item 19 is analogous to this.
Yes, your lordship. It may be taken up with that. Yes. Much obliged.
Both of them is for the-
19, no, no. Should I proceed now or would you like me to continue with 19? Okay.
My lord, before my senior star, my lord, here in this case, my lord, in item number, my lord, 15, my lord, I received the extra copy today, my lord. And in 19, my lord, I am yet to receive the extra copy, my lord. Last occasion also, I informed this honorable court, my lord. Specific direction was passed, my lord, to give the extra copy, my lord, to me, my lord, in item number 19, my lord. So in view of that, my lord, I could not take necessary, my lord, instruction from the authority, my lord. 15 I have received today, my lord. 19 I am yet to serve with the extra copy, my lord.
You are for whom?
I am for my lord, Commissioner Power Department, my lord. Standing Council Power Department.
Lordship, there is tomorrow morning, your lordship, if you want, I can argue if.
No,
directly.
he is yet to receive copy. How can it be taken tomorrow
But
morning?
I was told the service has been completed. In fact, this is, I came for urgency in this matter.
No, I understand, but then he has taken a ground which we cannot brush aside.
I appreciate
And
it.
it cannot happen this week.
Yeah, I appreciate your lordship, very much appreciate. In fact, today
We are
morning
we are
also.
trying to push things, particularly, you are also outstation.
I am outside, I'm coming from Delhi. your
These are grounds we can't do anything.
lordship. I appreciate your lordship. Expediency cannot be allowed to encourage lawlessness. I
Correct.
can't insist.
Copy was not given, Mr. Deuri. You have not given copy. This morning you gave copy. After the council comes from outstation.
Oh, sir, there has been, it seems, a change in council. It seems there has been a change in council. The copy was given to someone else.
Kindly page the order in item number 19, last order, my lord. There is a specific direction, my lord.
In fairness, your lordship, I can't insist on arguing at the moment. In fairness, whatever may have happened. But an early date may be given, your lordship. The matter, there is some urgency.
Would you please indicate a preferable date?
About
A
next
date
week,
convenient to all of you? We'll fix it
next
according-
week, your lordship, sometime. Your lordship, if you notice the
Not
order
next
in
week,
the
my lord,
previous.
even this item number 15, my lord, this is coming for the second time.
Yes.
And very recently, they have served the extra copies. According, we have communicated to the department. So it will take time, my lord. And item number 15 and 19 both are analogous, my lord. Issues are same.
So, all right, why don't you agree on a date? There is a outstation council coming, we'll fix it accordingly.
So give us reasonable time, my lord, so that we can come up with a detailed affidavit. It's coming for the second time only, my lord.
Why don't you agree on a date?
Lordship, I am open to, it's election time, so there are not many things happening. So 26, your lordship, if that is acceptable to them, I am okay with
26th April.
26th. April, your lordship. No, March. Your lordship, I was talking of March.
Not March.
Too early. Okay,
Somewhere in
then
April,
first
my
week
lord.
of April, your lordship, first week.
No.
You can give a date.
As your lordship suggested, somewhere in 24, 25, any suitable date you can choose, either 24 or 25.
See.
Or
24th.
you can count it from 22nd to 26th, any date.
Make it Monday. 22nd, your lordship, it's a Monday, so I can travel on Sunday.
22nd of
April, your lordship.
Let it be 22nd of.
My lord.
But lordship, they must, I should be allowed to argue for interim relief at that time if they still choose to delay the
All right,
application.
please listen to the order. You are Mr.
Abhay Kashyap.
Sure. Mr. Abhay
Kashyap.
Kashyap, Planning Council. You write this in item 15, appearing for the petitioners in this case. Has submitted that there is urgency in the matter in as much as his clients are pressing for an interim order. However, Mr.
El Perme, my lord.
A.
El Perme,
L permit.
my lord.
All erased.
Yeah.
2 years have not come,
Well.
everything. L Permin, Learned Standing Council, Power Department submits that copy of the extra copy of the, submits that extra copy of the writ petition has been furnished to him only this morning, in as much as he is yet to receive copies of the writ petition in the connected item, being item number 19. You write the case number. Therefore, he is not ready to conduct the hearing of this case today. Similar is the stand of Mr. Give his name. Additional AG,
My lord, your lordship can say government advocate, no issue, my lord.
government advocate AP, who also prays for some time to seek instruction.
I'm for response number 1, 2, 5 and 7, my lord. These are the respondents.
1, 2, 5 and 7,
My lord.
who also prays for some time to seek instruction.
Response number 6.
Mr.
Yes, Dave.
S. Deb,
Yes, sir.
Planning Council for the response number 6 and Mr.
We come to proceed.
We come to-
Number 4.
Planning Council for the response number 4. I have also prayed for fixing this matter along with item number 19 on another date. After considering the request made by all the learned counsel for the parties and in view of the urgency expressed in the matter, this writ petition is directed to be listed along with item 19 as fixed item again on 22/4/2024. Full stop. Parties to exchange pleadings by serving advance copies upon the counsel for the opposite party. On or before 12th of April 2024, the prayer for interim relief made Commissioners Council shall be considered on the next date fixed.
Much obliged.
Just a short-
Number 6, 16.
Item 16,
Please, your lordship, it's a matter pertaining to BRS. So day before yesterday, I have received a copy of affidavit from the election commissioner, civil
you
election
want to file
commissioner.
rejoinder.
I would like to file rejoinder. Yes,
Alright.
sometime may be given.
And the counsel for the writ petitioner, Mr. Swenson submit that only day before yesterday, he has been served with a copy of the counter affidavit filed by the department and therefore be granted 2 weeks time to seek instructions and file rejoinder. Mr. N. Ratan, learned additionally, is present on behalf of the official respondents.
No, I appear for 1, 2, and 4.
1, 2,
The
and
election commission.
Your Lordship,
And-
I'm on behalf of senior advocate, for
And
respondent
Mr. So-and-so for respond number
2, Lord.
2, 1, 3, and 4, and 2. Who do not have any objection to the above prayer. Let this matter be therefore listed again after 3 weeks.
Okay.
17 and 18, there was a prayer for adjournment. Why he wanted adjournment?
Lordship, since the pleadings are completed, Lordship, in this matter, Lordship. So this matter may be posted for hearing. Lordship.
For writ petition has been admitted.
No, Lordship, not been admitted yet.
So admission hearing,
Lordship.
yes, is it?
I on behalf of respondent number 5, my lord.
So we'll post these cases for admission hearing when? After?
After 1 week, Lordship.
After?
1 week, Lordship.
My lord, the urgency is there, my lord. Any that,
After 1 week.
because your lordship must have seen my by order, my lord.
So that's what you say when you want. Actually, you write the names of the councils, huh? I don't know, so and so for the petitioner, so and so, so and so.
My lord, can it be on 22nd, my lord? 26,
26.
26 March,
So and so.
because there is stay order, my
It
lord.
is submitted in the bar that all the parties are represented in this, in these proceedings, and the pleadings have also been exchanged. As such, in view of the urgency expressed by the respondents' council, these matters are directed to be listed for admission hearing on 26/3/2024 as fixed items.
Lordship. Lordship, there is an interim order that may be continued.
Interim order passed, interim order operating in this case shall stand extended till the next date.
Lordship.
I propose to say this regarding item number 7 matter. I will read out of session some personal difficulty. So may I fix, plan for fixing the matter on 1st of April matter? With consent of the.
This is item number
7, your lord.
Item 7, you write, Mr. D.K. Sharma, learned SC IOCL is present on behalf of respond numbers
1, 2, and 3.
1, 2, and 3. However, the petitioner's counsel is absent.
Well, it is different.
B type of on
Okay.
yes.
However,
Leading counsel is our side.
the arguing counsel appearing for the petitioner is out of station and therefore a prayer for adjournment has been made. Considering the request made at the bar and as agreed to by both the sides, let this matter be listed again on 1/4/2024 as a fixed item. Is there any interim order?
Yes.
This is limited in time, interim order? All right. The
Okay.
rest of the matters are 2.
The page order is on order that is 15/3/2024. My lord will kindly come to the bottom. Signed by Taya Kena. Order dated 15 so and so. It is 16:25. 16:25 PM. That is my lord Friday.
No, just a minute. The petitioner was posted where in the Yazali division?
Yes, my lord.
From there, he has been transferred and posted where?
To Office of the Chief Engineer, Vigilance, Eaton. Why is the private respondent who was holding that particular office. my lord.
Hmm.
Now, my lord, simple question is, on 15, my lord, at 4:25 PM, the order was issued at Civil Secretariat, Itanagar. At Itanagar, my lord. Then what happens, my lord? The
No,
KBA.
Mr. Tara will come to these things.
No, just, I'm
No,
just trying
you
to assist
will,
my lord only.
just a minute, you
Correct,
present
correct,
your
correct,
case,
correct.
but please tell us, what is the ground on which you are challenging this order?
Yes, my lord. Before coming to that, my lord.
No,
only-
you
only
have to
one,
first tell the ground.
my lord, I'll assist the court.
These are particulars.
Yeah, yes.
You tell the ground.
The ground for challenge is that, my lord, there is a 0206/1998 guidelines, which says mid financial year transfer and posting is not permissible at all, my lord. And, my lord, what we are seeking is till 31st, there is a WT message also. As a DDO, my lord, I have to return the utilized and unutilized check folders and submit it before the deputy commissioner, my lord. Number two, then I have to reconcile the account, my lord. Then that on that propositions, my lord, kindly come to this particular guidelines, my lord. My lord, the type copy starts from page 22, annexure 3. My lord, 25 is a type copy, page 25.
So the challenge is only for violation of 2/6/2000
This-
1998.
Yes, but it says ki no transfer, E, my lord, 1E. No transfers should take place in the last 3 months of financial year. Now, my lord, I'm left with less than 15 days, my lord. I have told my reliever, since in another 3 months, I'm going to be promoted as the superintending engineer. You please come quietly and take charge after 31st of March, which I am ready to hand over to you. And, my lord, now the second part, my lord, the second limb of my argument in this repetition is that I was appointed as the section officer for the election duty by the deputy commissioner. Then there, my lord, will kindly come. Please. Annexure 6, my lord, page 31, my lord. I figures at, my lord, page 33. I have this MCC, my lord, one more ground. Now, this is the particular point, my lord. My lord will find my name at serial number 16, my lord. Now, my lord, MCC has come, my lord. At page 35, my lord. 16. My lord, 16 is Saturday, my lord. The model code of conduct for the simultaneous Lok Sabha and, my lord, the Legislative Assembly of Arunachal Pradesh was declared on 16 March 2024 at 3 PM by the Election Commission of India. Thereby, my lord, the model code of conduct comes into force, my lord. Now, my lord, 17 was the Sunday, my lord. 17 was the Sunday. And, my lord, even if this impugn transfer posting is issued, order is issued, then it is not implemented. In view of paragraph 12 of this model code of conduct, my lord, kindly come. Page 38, my lord. My lord will come to Roman 4 is straight, my lord. The transfer orders issued in respect of so and so category, my lord, I come under this. Of the officers prior to the date of announcement, but not implemented till date, should not be given effect without obtaining specific permission from the commission in this regard. My lord, be that as it may. On 15, you sought to have transferred me from there. But Saturday, my lord, Sunday, and today is the 18th, my lord, today is the official working day. Now, my lord, what mischief the engineering department do, Lord, let me enlighten you. What they do is, immediately, my lord, they will take the ex parte charge. And then also they will flaunt everything in connivance with the people in the power corridors. So now, my lord will see, my first prayer is that I may be allowed to complete my function till 31st of March for reconciliation of the accounts, to submit the used and unused folder of the checklists. Then, my lord, in terms of 1F of 1998 guidelines. That is first thing, one. I have also submitted the representation on that evening. Now, secondly, my lord, as of now, even if that impugned transfer order is issued by that time, now what happens is 16, the model code of conduct has come. Now, that cannot be implementable from 16 itself. Now, in that period, my lord, what these
That cannot be, that part applies to only those cases where the officers are the district election officer, returning officer, assistant returning officer, revenue officer, etc. Your client is not one of these. You read clause 1, 2, and 3.
With that 12, my younger says, the
You have
commission.
not read the whole clause. You are in a hurry, you only read clause 4.
The commission further directs that there shall be a total ban on the transfer of all efforts, officers or officials connected with conduct of the election. Kindly read this one. Transfer of all officers or officials.
Right.
So therefore, my lord, since I am already engaged as a section officer in the form of magistrate, so therefore, will it not amount to attract the model code of conduct? Or even if you have the power to transfer me, my lord, at least on propriety, my lord, you ought to have consulted
But
the
have you
election.
made the election commission a party here?
No, my lord, I have not made it. Well, my lord, just on bringing the fact, but fundamentally my argument is on that till 31st, my lord. Fundamentally, my lord, because state itself has framed it. I just, my lord, this morning, this Ajit Patwari judgment, I brought it, which my lord has rendered. There was another judgment on this till 31st. Which rendered by my lord only for Arunachal case. I remember somewhere in 2017 when my lord was here, I was the counsel, my lord. Now, my lord, kindly protect me till 31st. Till 31st, allow me to reconcile the accounts, everything I will go. At the first place, my lord will see that Govardhan Lal case also. My lord will see that, Mr. Tara, your client cannot insist to remain in particular
Tara,
place.
very frankly, I'm not understanding what is this reconcile and all. How is that you are interested? This is for the government department to decide. What is your interest in reconcile? If it is not reconcile, not reconcile.
Because of this particular WT message, kindly come.
Which WT message?
Space 30.
See, is it that the ground is something else which you can neither plead nor argue? 31st March.
Correct.
That's the whole thing.
That's the whole thing, my lord.
You want to be in, you be there, but you cannot deal with any payments.
Correct, my lord.
You are agreeable to
Till
that?
31st, yes, I agree.
No payment, no checkbook, nothing.
No issues, my lord. And then, my lord, secondly, I have not received a copy of the caveator. Copy of the caveator. Now, my lord will also have that in mind. They might say that on 15th evening, after 4:25 p.m., they have taken the ex parte charge, my lord. Number two, they might also come up with a statement with a document, my lord, prima facie, saying that he has been released by the RO of the district from the election duty, my lord. And also might say.
But how do you know what he will say?
My lord, just my lord, out of experience, my lord. I am dealing with so many cases, my lord. So thirdly, my lord, they might say the superintending engineer of my concern circle.
And what
my-
your experience is, what will the court say when they say this?
No, therefore, my lord,
Interim order denied.
no, my lord, I'm only trying to say is that these things they might come up with and say that you have been released. But categorically, my lord, none of these orders are at my hands till today, my lord. So therefore, my lord, till 31st, I will not
Itanagar
sign
is
any
not a
checks.
bad place. You don't want to come to Itanagar. Itanagar is not a bad place. Everyone's posting. in
My
Itanagar.
lord, kindly see there. My lord's order is itself is only there. I can produce after 2-3 days only, my lord. That 31st till that 1998 guidelines F till midterm.
Which order? Which order? Should be?
You know, that, no, I'm talking about the guidelines, that judgment, I remember, my lord, that where my lord have dealt with, and other courts also, my lord. Well, till 31st, my lord, kindly, my lord. And my lord, I'll agree to the condition that I will not.
Why should we be there till 31st? No purpose will be served.
Purpose, my lord, will allow me to reconcile the accounts up to date. Because I am the drawing and disbursing authority as well. Total number of projects, how much money has been spent, how much balance are there. These things, my lord. And then checks, all those things I have to prepare. Even, my lord, I should be, at least, say for example, my lord, at least I should be given a reasonable day or two to prepare the paper, my lord. So therefore, my lord, this is there, my lord, kindly consider me, I would only beseech my lord to look into this in view of this guideline.
I've taken the instruction. That's now. Okay, so this instruction issued by the Election Commission of India. It was see the serial number 2. The commission has been following a consistent policy, like the officer directly connected with conduct of election in an election going state of the duty are not posted in their home district or places where they have served for consistently long periods. The petitioner is not very constituency of the petitioner. And it was there are 3 also relevant. Now coming back to the policy of the state government.
We is from Yazali.
And coming back to the policy of the state government, that's the guidance on the posting. It's page 24 of the report. This instruction was issued by Election Commission of India. It will also see the past, page 25. Page 25. This is type of the guidelines to the government. No officer of group A and B. No officer of group A and B should be posted in his home so that he does not develop aspect of this. The petitioner is also in group A. Definitely he falls under we are also in violations of this message. One itself. And so for B is concerned, 1B. Basically, normal tenure. Now it has been given 3 years ago, but now it has been amended 2 years. It's a normal tenure. The petitioner has completed more than 3 years, 3 years and 9 months in this posting phase. And then was it so far the present status is concerned. I have just mail was bad. It's in instruction. It was see the annexure 6 of the writ petition law. Where laws if the petitioner is found to have been engaged in election duty. Now that has been modified in view of this also. The private respondent has been located in place of the petitioner law. The private respondent has been given the charge because he has already taken the charge. Even that this private respondent has been given the election duty for this particular engagement, which was earlier given to the petitioner. Now, and if look at the next page, then already charge has been taken.
Charge is taken? My lord, my presumption was correct. My lord will see.
And one important submission.
Yeah, please.
If you also see the within in the writ petition, that is statement is that the order was issued, order was issued on Lordship 4 p.m. on 15th. If Lordship see, petitioner had filed a reapplication on 15th itself. If it was filed on 4 p.m., then how this reapplication was filed? Lordship? Petition to be very quick enough. Lordship. On 4 p.m. on 15th, if the order was
I
filed,
made it.
on the same day, Lordship, he even filed a reapplication.
Yes, that's not.
This is Lordship something which is not Lordship acceptable to our logic. And after executing the Lordship duty law, the private restaurant also Lordship is doing his work. And LTC was Lordship imposed on my friend has submitted Lordship 3 p.m. on 16th Lordship. And prior to the Lordship, everything has been and that also has been taken over. Now at this juncture Lordship, when election duty has been already Lordship given to the private respondent after his beginning as a union. If this is still Lordship, any importance otherwise also the petitioner he has completed 3 years. And he is there in violations of the very guidelines. It was more than 3 years he has experienced. And he is from very constituency. And for these 12 days, why he want to be here? Because and in support of their laws.
That he will tell you once you meet him outside the. You cannot tell this inside the court.
And
Why he wants to be there.
And this to have clearance of all these documents. Yes, completely under the domain of the authority. We have to look into all these issues. The petition need not worry on this lawsuit. Which document has been clear or not.
The moral of the story is don't hold election or declare model code before 31st March. It creates big problem for engineers. That is the moral of the story.
Now, as a committee, and this is junction law. When always the charge has been taken, and even he has been given the election duty. So it is it will create some sort of inconvenience to the authority in view of the election only. Otherwise, if outlook has also objected for this 12-13 days. Because otherwise,
No, you are quite right on that. Ordinarily, the court would have been inclined to allow him till 31st. But election commission is not a party here. And there is an order of the election commission which has been brought to the notice. So you must decide what you want to do, Mr. Tara. Please understand the complexity.
My lord, I have two options, my lord. First option is to withdraw and file fresh.
No, that you decide. We are not giving.
Just I'm submitting. I'll implement the election commission.
You have got these documents.
Yes.
Huh?
No, my lord. Just
Take it. Give him a set. If you want, we can post it tomorrow morning. Go through this and see what you want to do. Because you understand, ordinarily, this 10-15 days time, the court would normally accept.
Yes.
But this is not an ordinary circumstance. This is a very different circumstance with the election notification coming. And though court is not debarred, but then the court will follow the constitutional mandate.
Correct.
So therefore, unless you can make out an exceptional case, will be very difficult. Minus the election code, yes. Maybe 15-20 days, we could have just asked them to consider. Whatever be the reason.
Well, my lord, only thing is kindly appreciate, my lord. Let us not be on the law for a moment. The fact, what is Malaysian fact here? The Malaysian fact is that at 4:25 p.m. Lord, the order is issued, as I have demonstrated in the impugn order. Lord. Now,
Mr. Tara,
well,
I understood all these things. Should we post it tomorrow or you want to withdraw today? Don't take a rash decision. Let us have it in the list for motion tomorrow. We examine this and consult the law and then take a firm decision. Because this is going to be a big factor, the election
Correct.
commission.
well,
Normally, the courts would like to rescue. But election commission business is a different business.
Correct, correct, I understand.
Once it is brought to the notice of the court, that he has been assigned election duty.
For a day, can there be a status only for a day, no? Then tomorrow I'll take a call.
We'll just post it tomorrow morning if you want,
Correct.
for motion. You also appear, your name is shown in the cause list. Is your name shown? On the request of Mr. T.T. Tara, learned counsel appearing for the petitioner, let this matter be listed for motion again tomorrow, give the date, by reflecting the name of Mr. S. Tapin, learned G. Assam, as well as Mr. Mr. So, you know his name? R. L. Thungan, learned counsel for the respondent number 4 in the cause list. Examine this, look at the constitutional provision. It is not just about one transfer order. It is about following the constitutional scheme. Once an election notification is announced.
That now I can recall.
I want to pass an order after you have read the constitutional scheme. Otherwise, I would have passed the order.
Election matters, courts should not interfere, that is the law.
Sorry?
In any case.
Sorry?
In election matter, the court should not interfere. That is one aspect that I see, but. yes.
No, it's not that court cannot, but unless an exceptional ground is created. Just because somebody has passed an order at 4:30 and some checks need to be reconciled, certainly on these grounds, the court will not interfere.
Whether
So I think you better advise your clients and tomorrow bring a closer to this. But you come prepared, and in any case, without the election commission, no order is possible.
Cannot possible. So, may I, in that case, kindly give me a liberty to file press. I'll make the election commission as a party. If my lord don't feel offended, because order has been passed. Normally, I do not make this kind of request.
She is already left. Strike off the earlier order, huh? You're right. During the course of argument, Mr. Tapin, learned G. Assam, has produced a copy of the notification dated 16/3/2024, by means of which the respondent number 4, upon his joining at Yajali, has also been, pursuant to the impugned transfer order, has also been assigned election duty to submit that at this stage, no interim order be passed without hearing the ECI, Election Commission of India. Responding to the above, Mr. Tara seeks leave of this court, that Mr. Tara, learned counsel for the petitioner, seeks leave of this court to withdraw this writ petition with liberty to file afresh. Prayer stands allowed. Writ petition stands disposed of on withdrawal with liberty as paid for.
Grateful. Jaldi.
Item number 20.
When the interim order is paid for in the writ petition was not granted, the petitioner had to file writ appeal. And then it was disposed of by staying the order, supply order passed by the department. And to hear this pending writ petition, that writ appeal has been disposed of.
Where is
But
the
on
order?
the date, when this matter was fixed for this consideration of interim prayer, petitioner could not take steps to respondent number 6. So on that day, we had prayed for justice service, and it was accordingly allowed. So the petitioner went to the proprietor Pachav Enterprise, who is respondent number 6 here. But he did not accept the notice. And that apart the respondent number 6, he is well aware of the pendency of this writ petition. And that I will demonstrate lordship. I have filed affidavit in that regard. My lord may
Kindly
You're appearing for. There is.
Yes, my lord. My lord, the network is problem here.
Network is problem.
My lord, may I please come to page 26, my lord, of the writ petition, my lord.
My lord, since,
This board proceeding, my lord.
for the department, he's there. My lord may hear the matter, Lord, because this.
That's all right, but service has been accepted on respond number 6.
Yes, Lordship,
Where is the,
that is, where Lordship, I have filed one additional affidavit. And Lordship may take up that additional affidavit,
13th March 2024.
additional affidavit, Lordship. Yes, yes, Lordship. There is only one affidavit, Lordship, that is filed by the petitioner. It is. My lord, may I come to para 2 of my additional affidavit, Lordship.
And by which order does this service was permitted?
That was, it is annexed here, Lordship. By order 7/3/2024. At page number 7 of my additional
You take
affidavit.
down, Mr. D. Kamduk, learned counsel for the petitioner, has invited the attention of this court to the additional affidavit dated 13/3/2024, filed by the petitioner as proof of dusty service of notice upon the respond number 6 as per order dated 7/3/2024 passed by this court, to submit that when notice was offered to the respond number 6 for service upon it. The respond number 6 has refused to accept the notice. Since refusal to accept notice issued by the court amounts to service of the same, hence, in view of the statements made in paragraphs 1 and 2 of the additional affidavit, this court is of the view that service of notice upon respond number 6 is complete in this case. First up. Mr. Kamduk submits that since the respond numbers 1 to 5 is already represented by Mr. B. Picha, learned SC, RD, hence this writ petition be posted for early hearing. First up. Considering the request made by the petitioner's counsel office to verify as to whether any counsel has entered appearance for the respond number 6 and list the matter. Has it been admitted
Not yet, Lordship.
for admission hearing after 10 days?
Lordship, it's pertains to this contract, Lordship. Therefore, Lordship, since Lordship, may I just show two documents?
It's not hearing. You can't, it's listed for orders, acceptance of service.
Lordship, in that case, Lordship, petitioner will be prejudiced because Lordship, from the document supplied by the department, it is apparently clear that there was illegalities.
No,
I
no,
was
the
the
matter will have to be listed again for admission.
Lordship, till then, Lordship, I may be protected because by staying the order, supply order issued by the department, Lordship. Otherwise, Lordship.
We'll have it on Thursday then. List for admission on Thursday. Coming Thursday, please. Thursday.
Right.
Item number 21, 22, 23.
What is this regular first appeal? Why 3 appeals? 3 of the defendants.
3 of the.
Yes.
Before my learned friend starts, although we have filed the affidavit, that was filed in the year 2017. At that point of time, we were governed by the Bengal Agra Civil Courts Act.
Hmm.
Now there, we have our own AP Civil Courts Act, which came into force on 2021. Now, my interpretation is that now the appeal will lie before the district judge, subject to what my senior says. It may lie now, but then it didn't lie.
No, now if it lies, it will go there.
But no, my lord, this is a pending case, my lord. Because in fact, earlier I filed an appeal before the London district judge.
This is 50 lakhs, decree is for 50 lakhs,
Yes, 50 lakhs.
50 lakhs.
Yeah.
So district judge, will it have the jurisdiction of 50?
My lord, as per the AP Civil Courts Act, it's not even
Yes.
clear, my lord. No, it is not clear what it says, my lord. In any case, my lord, this new act
No,
cannot.
Sir, please understand, these are jurisdictional issues.
My lord.
You cannot brush it aside. Your argument that when it was filed before
Yes.
the court, the law was different,
Yes.
that you forget it, that doesn't help you. The law as it holds today will only be applicable here. In our high court also, many matters have been transferred subsequently. So that matter, there is no debate required, that is the position.
In that case, my
As
lord,
on date, if this court is having the jurisdiction to take up this matter.
yes, my lord, yes.
If it is, doesn't have the jurisdiction, then it has to go to the court. What happened, what was the law at the time of filing, that doesn't have any.
My lord, this honorable court has, my lord.
He is saying it doesn't have, let us see why he says so.
If, AP Civil Courts Act, volume 16.
Which law you are referring to, Mr. Ratan?
Arunachal Pradesh Civil Courts Act, volume 16. It's in the court. Yeah. Soft copy.
You are appearing for whom, decree holder?
No, my lord.
Then,
I am also one of the respondents, my lord. The fight is between all the defendants, my lord. Between the defendants, not between
no, who was the plaintiff?
plaintiff is Mr.
You are the plaintiff.
Yeah.
There were three defendants.
Yeah.
You are one of the defendants.
Yes, my lord.
You are another, and he is one of the defendants.
Yes, my lord.
The decree is defective. It cannot be executed. Because the decree does not say that it has to be recovered jointly and separately. Therefore, the amount cannot be recovered. You better do some homework, because the more you delay on that, more your clients will be prejudiced.
Exactly,
The
my lord.
decree is against 3%,
Yes.
but it does not say it will be jointly or severally. So this decree cannot be executed. At least not by this court. It cannot be sustained. You have to ask for clarification. Unless there is a decree, if there is a decree against one defendant, then it is okay. But if there are more than one defendant, either the decree has to say that out
They-
of 50 lakhs,
Does not specify the amount, but say defendants are jointly and severally liable.
that's what. So to what extent?
That is not.
What extent? How will you execute the decree?
Right.
No, but that is a question he has to answer.
Yes.
On that ground, the decree will go. We have an answer to that. Huh? How much money you will take from whom?
Since the decree is jointly and separately means the principal amount, allowing 40% has to be equally divided among the three defendants.
So we'll go to that later. What about your plea? Let's see, which is the law?
My lord. 15 to section 15 to
15-2.
yes. Where it exists in respect of additional district judge. District it says either to the district court or to the high court.
Who has passed this decree? Civil judge.
Yes, senior division. In fact, we preferred an appeal before the district judge earlier, but because the Bengal Agra was applicable. The word, sir, my lord. to the district judge or the additional district judge where such court exists, that is the court of the additional district judge, or to the high court. That's the case.
But there is no pecuniary.
No, the whole act is defective, many provisions.
Defective, but why it says either district judge or additional district judge or high court?
Yes.
My lord,
In
therefore,
the pecuniary jurisdiction as per the Bengal High is not there.
only the pecuniary jurisdiction of the junior division
Is already there.
up to,
So my lord,
up to 10 lakhs. This in the previous section. my lord.
What is the pecuniary jurisdiction of the district judge to entertain the original proceedings?
the district judge will exercise original jurisdiction only in respect of my lord where it is empowered, otherwise it's a civil judge, my lord.
That's correct, but if he is to empower
That has also not been notified.
so what is to be done? First, this has to be sorted out.
In my humble understanding, my lord,
Oh, it's not about understanding, it's about a determination of this.
yes.
So the court has to first decide whether this appeal will lie before the high court or it should go to the district judge or you have to address arguments on that first.
My lord,
Yes, my lord.
there,
What I am
my lord, it
submitting was-
says where the district judge or additional district judge exists. And or the high court in, as the case may be. Here, in some of the districts, some civil judge senior division has the immediate, the district judges or the additional judges. Some does not have.
Which
No,
district?
no. This is Papumpara, UP.
Papumpara, there is a district judge.
Yes, my lord, UP, there is a district judge.
No, my lord. Supposing, say, Lower Subansiri, supposing in Kurumkume there is no district judge. District judge of Lower Subansiri will exercise jurisdiction over it. That is notified, my lord.
No, Mr. Pani, you are not understanding this. If there is a serious issue, because if this appeal is heard by this court,
My lord.
the second appeal will lie in the Supreme Court.
I understand, ma'am.
But it doesn't happen in normal suits.
Yeah.
In suits,
My lord,
the
my learned
second
friend has
appeal
now all
comes
of a
to the
sudden
High
raised this. So can this matter be fixed tomorrow, my lord, so that I can argue on this, my lord, 15-2? Because the
this can be
execution
clear-
proceedings are pending, my lord. The notice for sending the appellant to civil prison has already been issued.
Execution proceeding pending where? There is
Here.
no stay of the decree.
No, my lord, the appellant, in my case, is not in a position to make any deposit, so no stay was granted. Money should, ma'am.
And why this 50 lakhs compensation?
Well,
Why, what is the basis of this 50 lakhs compensation?
but as far as I am concerned, the learned trial court applies section 72 of the contract act, which is not applicable. My learned friend is making the submission because ultimately the matter is all liability is going to come to him.
He is the
That is why.
beneficiary of all the money, my lord. He has taken the money, he has admitted.
They may say so, but record will
Yeah.
reveal.
There
Even
is an
the
admission by him.
plaintiff in the deposition has gone to the extent of saying, I don't owe any money to him. The plaintiff has said so. I can show to the deposition.
But where is the advocate general? Is he here?
No, my
No.
lord.
He has to explain now what is this act. Advocate general is not here.
No, yes, it's not here.
So tell me what is to be done now?
My lord, can it be taken up tomorrow so that
Day
I
after
can?
tomorrow, not tomorrow. Or I have other matters. Day after tomorrow.
If this can be sorted, my lord, then I'm also ready to argue on the merits, my lord. If this jurisdictional issue is sorted.
But you see, this bench is available only for another 2-3 days. These kind of matters are, I don't know, we can look at the jurisdictional issue at the most. We'll see day after tomorrow.
Otherwise, in that case, my lord, in that case, my lord, कब है? उसे कब?
Because commencing a hearing in this matter, if you can't conclude it, then it is a completely wastage. This bench is not going to be available here. That's something you have to decide. Since this point has been raised, it has to be answered. At the commencement of, please take down. At the commencement of hearing of these appeals, Mr. N. Ratan, Learned Counsel appearing for one of the appellants, has invited the attention of this court to the
It starts from page 9, honestly, that is civil court side.
Arunachal Pradesh Civil Courts Act, number 2021, more particularly, Section 15 of the Act, to submit that after the enactment of the aforesaid Act, there is a doubt arising as to whether the present appeals are required to be heard by the High Court, or the matter should be remanded to the jurisdictional district judge to hear the appeals on merit. The said issue remained unresolved today. On the request of learned counsel for the appellants, let these appeals be listed again day after tomorrow, that is, give the date, so as to enable them to come prepared and address argument on the point of jurisdiction of the court to hear the appeals. To get it resolved first, because otherwise, later on you will find that.
But
the
I
things-
did not bring the act, otherwise, my lord, from the reading of the act, from the very beginning, additional district judges has not been constituted in the state of Odisha. That is why the word if they exist. It is only in respect of the additional district judges. I will address
No,
on
you
Monday.
see, normally, appeal from the Court of Civil Justice Senior Division will definitely go to the district judge.
Yes,
The only reason why it will not go is if the pecuniary jurisdiction
yes.
bars,
In Assam, 10 lakhs now,
not 10 lakhs, 20 lakhs.
20 years.
So unless you can show that the district judge does not have the pecuniary jurisdiction to hear an appeal where the value is 50 lakhs, it will go to the district judge.
But the act itself does not provide anything, my lord.
Then it will go. Because that is the normal code, because you have to read this in tandem with the CPC. Read CPC, section
Yes.
94 and all these things. And order 41. Read it. So we will interpret these provisions and fill up the lacuna by referring to CPC. So if there is a gap here, it has to be read by the CPC. So CPC says the decree has to be appealed before which court? The only ground when it will come to the High Court is when the pecuniary jurisdiction does not permit. Otherwise, all first appeals have to be heard by the district judge. That's the law. Now, you say that there is no pecuniary jurisdiction, then it has to go to the district judge. Second appeal will be heard by the High Court.
But when the statute provides or the High Court, because there is an option given.
That's right. Option of, then you have to address the court on what is the meaning of this option. What happens is, many cases, thousands of cases in Guwahati recently has faced this problem.
Yes,
Those are all sent back.
because of the amendment.
Some amendment
Yes,
you can figure out, you can.
yes, I have seen.
Hundreds of appeals have been then again sent back. And the law which governs the field today will be the law, not when it was filed. So you may be right in saying that the statute is not clear. But that cannot be a ground for us to ignore the issue. It has to be addressed. And this will have future ramification, not only
Yes,
for
yes.
this case, for other cases.
That's why exactly.
That is,
So you cannot just say that this is my understanding and all. You have to really address argument. Had he not raised this point, then the court would have proceeded with the hearing. Now that it has been raised, recorded, this plea has to be addressed. And you will also have to argue. Because you will be the worst sufferer if the wrong court does it. If the High Court wrongly hears the appeal and affirms the decree, that order will go. If the court doesn't have jurisdiction and vice versa. And all your effort, time, energy will go in waste. This is a very important issue. Jurisdiction and limitation, there is no answer to this. You can take bank's money and digest it and forget it if it is barred by limitation. You can ignore any decree of any court if it is barred by jurisdiction.
Yes.
There is no escape from this.
That is.
You see the Omkar Mills judgment, 1977, 8 SCC or something. Once there is lack of jurisdiction.
Yes, the recent judgments also. Obligement from it.
Obligement.
After two.
Item number 24, 25, and 26.
Your lordship has put me in a dilemma by your comments in the previous matter.
Sorry?
Your lordship has put me in a dilemma by your comments in the previous matter because this matter is fairly complex and will take some time. Your lordship very right, and I have already argued it thrice, your lordship. So I don't know. Maybe we can start now and I can stay back tomorrow also, but it seems you are very busy tomorrow from your comments. I don't know, your lordship. What should I do? Because you were very straightforward in making your comments.
No, we don't have any problem, but the point is,
मैं तीन बार
very
28
short
I have-
benches and then
Your lordship, I have already submitted written submissions. So if your lordship permits me, I'll take you through those quickly and you can depend on my honesty in having quoted correctly from the pleadings.
what is this matter about?
Your lordship, this is a very interesting matter. It is a subsection of the Trans-Arunachal Highway of 30 kilometers, which was bypassed for apparently technical reasons, and a 15-kilometer shortcut was passed and allowed by the Honorable High Court in a PIL, where the residents of the original section said that it should continue on the original section. And interestingly, your lordship, even the state wanted it on the original section, but the central government and the contractor wanted a new section. So that was allowed by the High Court. Simultaneously, but the High Court took note of the state's desire to have a similar standard road on that section, that is the old BRO road section, which was 31 kilometers and the new section was 15 kilometers. So on the 31 kilometers, the Honorable High Court in the order, final order said that it gives the responsibility and duty of making a similar road as already proposed and surveyed by the state to be made simultaneously with the Trans-Arunachal Highway section within 2 years. Now, the section which was the new section and is an old section. The confusion was created by flim-flam on to and fro and changing policy or statements by the department on the issue of compensation on the new section. What had happened, your lordship, is that money had all, and the Honorable High Court in PIL 101 noted it, that money has come. And in fact, some of the petitioner had even received some of the funds. And we had come at that time saying that give us our regular due and also do not abandon this old section. At that time, when this order came, we waited that for the new section, procedure would be created for.
Your client's land has been acquired.
Yes, your lordship.
Okay, how much land?
Your lordship, the land is in contiguous manner. I don't remember the exact this thing, but the land contiguous on the 15 kilometers of the new section.
No, I followed.
Your lordship,
ultimately-
with due humility, your lordship, it's not that simple. What has happened is there has been to and fro going on in this case. If you allow me for 10 minutes, your lordship, I'll try to take you through the factual matrix. So then your lordship is better acquainted. So it's the key question here is the land has been acquired, then it was denied, then again it was admitted that yes, it and even the compensation was. So let me just take you in 5 to 10 minutes.
Please do it. But
Yes, sir.
the court is entitled to have a sneak peek.
That's
into
right,
the
your
matter.
lordship. Lordship, if
So
you
I'm
don't,
asking you, what is that you are asking for? Your clients are asking.
we are
for what?
asking for compensation, your lordship,
Compensation for what?
for the land.
Land
which
has been acquired.
Yes, your lordship.
How much land has been acquired?
It's on the 15 kilometers, all the persons are party here and their assessment has been done. I don't remember offhand the quantity, your lordship, in hectares. I am telling you what I remember and what is there in the case. The contiguous 15 kilometers of the new alignment, the lands of the people who are owners there, which has been acquired, road has been built.
So, Mr. Kashyap, the reason why I am in a way interjecting is to put it across very straightforward. See, these matters are simple. If people, their land has been used or utilized for state roads, etc., they will have to be paid just compensation. If that has not been done, the court is required to pass orders, putting the machinery in motion. It doesn't take a long time to hear these matters. But as far as this court is concerned, there has to be a prima facie satisfaction on certain facets. Number one, that the people who are the petitioners here, they action with the quantity of the sales and some description of the land must be there, number one. Number two, is it that section 4, section 6 notification been issued?
Lordship.
Has not been issued?
No, it was all, lordship, we went to court and it was issued after we went to court on that issue.
Section
And in
4.
fact, quantification of our dues was also done, but it was first done under the earlier act. So the only issue, and it was a consent order, and in this is writ petition 17. In fact, our case in contempt is that order has not been given its due. So what your lordship has just mentioned, quantification, identification, all that has been done under the power of the writ 17. But your lordship, it was not given effect. And when it was not given effect, we came in contempt in 15. That is the first matter in front of your lordships. Then your lordship, while the contempt was going on, they cancelled our LPCs. So we came in the next 359 of
They
2000.
cancelled your LPC.
Our land possession certificates were cancelled, your lordship, to avoid giving effect to the order of writ petition 17 and to avoid.
Where is the order?
Yes, your lordship. Lordship, if I may so submit, if your lordship can take the written submissions, I have quoted the orders, your lordship. It will be much easier.
I would just like to
Okay,
see the
lordship. Contempt.
Mr. Kashyap, these matters will take time.
That's why your lordship, right in the beginning, I said you have put me in a dilemma.
Everything has to be verified.
Malad, in a contempt, since Malad, the contempt is for the compliance of the order passed by the Honorable Court, Malad, that has already been complied with. So at this stage, Malad, may I pray that the contempt can be closed?
No.
Since writ petition is,
How it has been complied?
Malad, some direction was given.
That's what I want to see.
Never.
Malad, it is in annexure, contempt petition, Malad, it is annexure, page number, Malad, it starts from 37, Malad, annexure 6.
17.
Contempt petition, Malad, annexure 6, page 37, Malad.
Lordship, may I read the order of 17 as your lordship just directed?
Just a minute. Where is the contempt case? The writ petition. Where is the contempt case? The record is not here.
It must be taken with, because it is in item number, Malad, item number 25, Malad. In writ petition, my lord, we are not party. But in contempt, my lord, as per,
Who is party in the writ petition?
my lord, in writ petitions, my lord, other respondents, my lord, state respondents, my lord. Union is not a party, my lord.
All right. Where is the order in contempt?
Page number 37, my lord. Of contempt petition, my lord. Page number.
This is the order I was trying to read also.
Operative person is, my lord, page 45, sorry.
Your lordship, with due indulgence, the final order is on page 42. The learned friend is pointing out to a interim
Page
order.
42.
The page 42 is the final order in this writ petition. And if your lordship were to turn to page 45, and also page 44.
No, let's please say with one number.
Yeah,
45,
lordship,
40,
page 45, your lordship.
45, madam.
Page 45, your lordship.
45, which
Para-
paragraph?
Para 4, your lordship.
All right, please, can you please read it?
Yeah, I am reading. In the aforesaid premises, we have arrived at a situation where the state authorities have initiated the process for land acquisition and the matter be brought to its end. But in Annexure 3, series of the said affidavit, this is referring to the affidavit submitted by the state, your lordship. The compensation payable has been assessed as per government notification number LM 63 2011 dated 26/11, which means, your lordship, the compensation rates as per the earlier Land Acquisition Act. Mr. Kashyap, learned counsel for the petitioner, has raised an apprehension that as the said land acquisition as per earlier Land Acquisition Act of 1894, the compensation as per the may be paid, and that further the said compensation is for community land and not for private land. So there was an error in the computation, your lordship. Then your lordship goes on to say, be that para 5, be that as it may, it is noticed that para 10 of the affidavit filed by the state respondents indicates that the primary notification had been issued under section 11 of the Right to Fair Compensation and Transparency in Land Acquisition Act 2013. And accordingly, it is understood that the respondent authorities would make the determination of the compensation as the provisions of 2013 Act. Para 6. Be that as it may, even if the acquisition process of land of the petitioner had been initiated as per earlier Land Acquisition Act, but by virtue of section 24, the right to fair comment transparency in land had, as no award was made under section of the earlier act. So, your lordship, what your lordship has held here is that the earlier act is not applicable. 2013 Act and rates as prescribed under that shall be applicable, and computation made. Then, your lordship, para 7. In view of the aforesaid provision, this writ petition is disposed of with a direction that the respondent authorities shall bring the process of land acquisition initiated by the primary notification dated 33/17. This is the notification which, after we obtained orders in writ petition 260 and 154, directed the state to issue notice to its logical end by following the procedure under the right to so proceed. As agreed, now your lordship, this is very important. This second last para is crucial to our case. As agreed by the state respondent, the said proceeding be brought to its end with 31/3/18, meaning thereby within the financial year so and so. It is clarified that when the proceeding has been initiated under 2008, therefore the entire proceeding, including that of compensation, be made. Now your lordship, as per this order, the state has come in, admitted its liability, given it on affidavit. The only thing that remained as a bone of contention on which adjudication was done by this honorable court was which act was to be used for the purpose of computation of compensation. Full table and everything they made. Secondly, your lordship, it has been clarified by his lordship that the 2013 Act should be used. Subsequently, your lordship, I take you to.
So then what happened? They cancelled the LPCs.
Lordship, then they did nothing. So we came in contempt. When we came in contempt, first they gave false affidavit. Several points I can take your lordship through, which are there in my submission, also written submission, were outright false. For example, they say, I'll give you 2-3 examples, your lordship. They say that in 101 itself, the state had held that compensation was paid on the new alignment, not the old alignment. That is factually true. But what they failed to say is they withdrew that, and the state was party to the honorable judge, noting clearly that the state wanted to have this on the old alignment. Compensation has been paid for the old alignment and collected and kept with the state from the central government. That is the observation in the order itself, your lordship. So they can't go back on that order. It's court record.
Just a minute, just trying to understand. So Learned Single Judge says the said proceeding will be brought to its logical end, right?
Yes, your
What is that proceeding? What is the number of?
Yeah, that proceeding is they have in their affidavit said so much land is belonging to, by name they have given. Area they have given in a table, affidavit mein, in the 2017 matter. So he is saying that this should be, but the computation has been done incorrectly on 2 counts.
Mr. Kashyap, just a minute, I'm asking something else. There is a reference to proceeding in this order twice. What is that proceeding?
This
Is there a number
proceeding,
of this
the proceeding in which they are computing, they have assessed our acquisition of the land and they have given a table in their this thing showing our.
Correct. So this is a proceeding under.
Yes,
the
yes,
statute.
your lordship. This was a acquisition, land acquisition proceeding.
Under which provision of which act?
Under that is the problem, your lordship. They had given the advertisement under the 2013 Act, which is what his lordship mentions here. But the computation is under the 2011 Act, which is what I pointed out to his lordship, that there is a error on the face of the record in their affidavit itself. So his lordship, on the submission that the land belongs to us, it's been acquired, the state has admitted. But the computation they have done is based on the 2011 Act's rates. So his lordship intervenes and says that as the advertisement, as the initiation of the proceedings is on the 2013 Act, the conclusion should also be under the 2013 Act. So it is talking about that, your lordship. And when this did not happen, we came in contempt. When we came in contempt, lordship, what has happened? May I seek your indulgence, tell you exactly what is the actual problem the government is facing. And it took us also time to understand. Because state doesn't have to worry normally about such things. If the court gives an order, they execute it. So I was wondering what is happening. And finally, I have realized what has happened, your lordship, is, and I am making this as a surmise from my side, your lordship. I'm not making it as a formal submission. I'm just trying to understand and thinking aloud. Your lordship, what has happened? Money was received from the central government. The original alignment was what everybody wanted. Suddenly, the contractor came in, made a submission that I want. The contractor also did a survey on the original alignment. His submissions in 101 are based on original alignment, which are on record. He comes in and he says that I'll make a shorter alignment. And that the court said, okay, he's saying, so it's a technical, this is central government supported it, court allowed that. But simultaneously, court gave an order that on the old alignment, an equivalent road must be made by the state. What has happened, your lordship? 45 crore rupees compensation came for this section. That compensation was partly given to the landowners in the old section. Partly, I don't know where it is. Now the problem is that when the order 2017 came, state government wrote to central government north that here this order has come from the honorable court. You kindly find funds to give the compensation. This is on record. I have put it on record, this letter. Then North writes back, how come we are not involved? We have already paid you 45 crores. We have already given you compensation. And we were under the understanding that you have given us the new alignment when you handed over. So there was a reconciliation done in 2017 within the administrative secretariat. And that clearly said that no, what we handed over was old alignment. No compensation has been paid on new alignment. No acquisition has been done on new alignment. And that is when the order for new alignment acquisition was taken out in the newspapers. And now the position, your lordship, is as follows. As per 2017, that is the state, recomputed, made a table of compensation to us, sent that to the central government, and central government refused to pay, saying that we have already paid you. So the problem is, I'm thinking aloud again, your lordship, they are not being able to understand how to reconcile this. We have already taken money, that money. So, and in their own note, your lordship, it clearly says, and when you go through my written submission, that note is quoted, your lordship, it clearly says that the state has to provide funds for this, as the court has also said that the state has to provide funds for this. So this is where it is stuck, your lordship. They at one stage wanted to pay us, they computed the correct compensation, and in RTI, they gave it to us also. That by name, this is your compensation, and it comes to some 30 plus crores for the entire people, all the people. The problem happened when they wrote to Morth, and this is my surmising, and now Morth said, no, this is your headache. Now, who will bell the cat seems to be the problem, my lordship. And that is where judicial intervention seems to be the only this thing, because within the bureaucracy, they seem to be, you know how it works. So, your lordship, this is the crux of the matter. All my submissions, sir, your lordship, what can I say? I mean, I have also handled a few cases, but normally, your lordship, I have 2 or 3 legal infractions on law points. This is a rare case, your lordship. There are as many as more than 10 legal infractions. I mean, on law. We have broken this law, we have broken that law, we have broken that law, we have broken that law. And we have done it with, as a, it seems, your lordship, again, I am seeking your indulgence.
Mr. Kashyap, I have understood. See,
Yes.
the point is, this matter is a bit jumbled up, and
Your lordship,
we
if you see this, you will find a lot of clarity, your lordship.
we can start it, but it is very unlikely that in these next 3-4 days it will be
Your
over.
lordship, your honesty and sincerity disarming, but I don't know where.
They will have to come back with the records. They will have to come back with.
Your lordship, सब कुछ कई बार आ चुका है. Your lordship, when you go through this, you will find considerable clarity.
But as a judge, I would like to see.
Yeah, your lordship, surely, your lordship. All I am saying is, in the compilations, the record is there. Whatever your lordship would be looking, your lordship.
Well, we'll start it tomorrow and carry on day-to-day basis. Yeah, Thursday, whatever.
I'm scheduled to go tomorrow, but I'll stay back, your lordship. I'll stay back.
No, but if it concludes, it concludes. Otherwise, it.
Lordship, I'll be very happy to.
Because this matter is a big jump.
Lordship, इसमें 2-3 hours चलेंगे. That is, it will need about 2-3 hours, your lordship. From my estimate of earlier, and I'll shorten it. My initial presentation was longer, I'll
Who is
shorten.
appearing for the state here?
There's not been.
Sorry?
The brief is not with me, Lordship. So.
No, but he's come to argue the matter. You can't say this.
I understand, Lordship.
This is the 4th or 5th time I have argued. I will be arguing.
Finding of the others. Someone was handling.
What is this? Then we'll pass orders without.
Can this method be taken up with senior?
How many times you have asked me this? I mean, this is the 4th or 5th time I'm making. Lordship, I have made arguments for our final argument. Then they say, okay, we'll do it later, and then it doesn't. The later never happens. And for me, it's the state. I'm not talking of individuals.
I understand.
For me, I'm not talking.
Who is appearing for the state? You will argue the matter for the state.
Without the brief, I'm not being.
Where is the brief? Who has the brief? Oh, it can't be like this. This is a high court proceeding.
Yes,
You can't.
I'm really
All right, list tomorrow.
I thought that content is going on with this.
Always.
Tomorrow it may be taken earlier on the board, your lordship. It may be taken.
Malade, as per,
I'll be here.
Malade, as per our affidavit, respondent number 1 and 2, Malade, we have complied with, Malade. Therefore, Malade, time and again,
Complied
Malade.
with means you have paid the money to.
Malade, as per the street plan, as per the approved rate, as per the Malade assessment done by the
Let us come
district.
prepared tomorrow.
Malade.
We will direct personal appearance.
Standing council is also there.
So those statements are part of what I am calling false statements, your lordship, and making it a case of
Whatever
perjury
it
and
is,
criminal contempt.
You come prepared and answer the questions of the court.
Lots of.
Otherwise, we'll have no option but to call the officers to appear personally. That will be embarrassing for you. You better find out what is happening.
Develop.
Yes, pastor for 2 weeks. You are appearing.
Malade, I am for the petitioner, Malade,
Who
here
is
issue
the
is.
respondent? What is
State,
it matter?
Malade. No private respondent, only statement. Malade, issue is very simple. One aspect is, Malade, as per the merit of the case. Another aspect is, Malade, the procedural violation, Malade. Malade, I was appointed by the Malade, the Assistant Inspector General. But Malade, termination, Malade, everything has been taken by the Malade, the authority who is above me, Malade. As per the procedure, Malade, there is a separate rules, as per rules 1999, Malade. The disciplinary authority is someone different, my lord. And the action has been, my lord, the termination order has been passed by the persons who is not, my lord, at all, my lord, as per the provision having jurisdiction, my lord, authority, my lord. That is one aspect, my lord, procedural, my lord.
Dismissal from service.
My lord.
You got the records.
Records would be needed, Lordship, but it's not with me, Lordship.
My lord, since I have annexed entire thing, my lord, the record may not be, my lord, there. It's because, my lord, the disciplinary proceedings, my lord, is from the statement, even, my lord, criminal case was registered, which was, my lord, discharged, my lord, the closed. And that record is also annexed along with. My lord, altogether, my lord, 3 persons were, my lord, the charged, and out of 3, my lord, 2 have got absolved, my lord, and the only punishment has been awarded to me, my lord, who is the, my lord, lowest grade serving, my lord, the FPP my lord, constable, my lord.
Yes.
My lord, from apparent.
What is the order of dismissal from 16/4/2015?
My lord,
Where is the order?
it is page number, my lord, impugn order, page number 63, my lord. Sixty-three, my lord. It starts from page number 63, my lord. Operative person, my lord, is page number 66, my lord. Arriving on wrong conclusion, my lord, this order has been issued, my lord, without considering the other material facts. Page number 66 is the operative. Now, therefore, by virtue of the power conferred by Rule 3 of the Arunachal Pradesh disciplinary so-and-so rules 1999, read with Arunachal Pradesh so-and-so amendment, there is no much change in the amendment. The undersigned hereby awards the penalty of dismissal from service upon constables Suraj Chetri with immediate effect, and the period of the suspension is treated as not spent on duty for all intent and purposes. This is the, and against this, my lord, I prepared an appeal before the appropriate authority, and that has been also, my lord, not considered, my lord. All this impugn order has been passed by the authority who is not, my lord, as per the provision, he is not authorized person.
Yes, sorry, 1 minute, come again.
My lord.
Impugn order has been passed by?
My lord, impugn order has been passed by the, not by the disciplinary authority, my lord. My disciplinary authority is, my lord, assistant, as per the provision, my lord, it is assistant Assistant Inspector General Police, madam. Assistant Inspector General Police, madam, or Superintendent of Police, or Principal PTC, Police Training Center, or Commandant BN, madam.
He is a higher authority.
He is higher authority.
Then,
So therefore, my lord, the disciplinary authority is, my lord, is my lord, as per the provision, disciplinary authority is the
this is
AIG.
number 1, number 2.
My lord,
First ground is disciplinary authority has not passed.
my lord. And
What is the
rather
other
this
ground?
other ground, my lord, the other ground is not basing on, my lord, the merits of the case, my lord. Everything state, my lord, disciplinary inquiry was constituted, my lord, the inquiry report finding is there, my lord. Everything is recorded, my lord. In that, my lord, record, if lordship fair use the statement given by the, my lord, the inquiry report, my lord, there is no, my lord, the prima facie establishment of the case against me, my lord. I was just a constable. Along with me, my lord, other constables were also present, my lord. At that relevant point of time, the my lord, UTP escaped from the, my lord, the custody. Not only fault on the part of me, my lord. I am the, my lord, the lowest constable ground.
That's all right. We are not going into all those things.
My lord.
You say that the order of penalty has not been passed by your disciplinary authority.
Correct.
This is number 1.
Number 1.
We'll examine it.
My lord.
What is the second ground?
Second ground as per not as per the merit of the case, my lord, as per the factual material evidence, my lord.
You mean to say the inquiry inquiry officer's finding is perverse?
Purported, my lord. Inquiry report, that fact, my lord, we so cause notice was issued and we have replied, my lord, everything that has not been
Mr.
taken,
Kato,
my lord.
leaving aside the expressions which may or may not be correct, you have to be very clear.
My lord.
In these matters, the grounds of challenge are very well demarcated and few in number.
My lord.
Number one, you can plead procedural violation.
My correct, my lord.
Number two, that the findings of the inquiry officer is perverse.
My lord.
Number three, the penalty is disproportionate.
Correct, my lord.
Generally, these are the three grounds.
My lord, exactly that we have taken, my lord.
Which of the three grounds are you taking? And the order has been passed by an officer not authorized under the law to pass.
Right.
These are the four grounds.
My lord.
Your first ground is, I don't think it will sustain because he is a higher officer. It should not be passed by someone who is below the rank of officer designated. But then we'll ask them to clarify. Which of the other grounds are you pressing into service?
My lord, other
And
ground
are
is,
there pleadings to that effect in the petition?
my lord.
Have you pleaded your case
Yes, my
about
lord,
it?
yes.
Which are the other grounds, please?
Other ground, my lord, as lordship has pointed out, that is the, my lord, the findings of the, my lord, the inquiry report is perverse, my lord.
Findings are perverse.
Yes, ma'am.
All right, where is the pleading first? Let's go to that. Which paragraph?
Page number 9 of my petition. And paragraph, my lord, it starts from paragraph 9, paragraph 10, and paragraph 11 also, my lord.
No, paragraph 9 is something else.
My lord.
Paragraph here can note of the fact that
Yeah. May I take your lordships to 18, paragraph 18, page number
Mr.
40.
Kato, you see, I'm asking you again.
My lord.
As I mentioned while earlier, these arguments will not work in these things. To set aside a order of dismissal from service, which the court will do. If a case is made out, the court will do.
My lord.
But you have to be very clear on what you are arguing first.
Correct.
Are you sure you have understood
Yes,
your
my lord.
case properly?
Yes, my
But para 9 is perversity, then you have lost it. There is no pleading of perversity here. Para 9 is completely something else which the read court cannot go into. Who should have done what? Who else should have been blamed? These are not matters for the read court to
Yes,
do.
ma'am.
You have to show us how your right has been prejudiced.
My lord, that it's specific, my lord, pleadings, my lord, may I come with, my lord, correct, my lord, pleading to that effect, my lord.
No. Before coming with correct pleading, have you gone through your record and are you ready to argue the case? What will happen is, as I go deeper, then you will say that, oh,
Yes,
give me time, and then there is a rollover. I have to adjust all my cases in 3 days.
My lord.
And if I hear something, I'm going to close it.
My lord. And then, my lord.
Regardless of
My lord.
whether arguments are concluded, that problem you will face. I'm not going to hear a case and then let it happen. If I hear it, I'll close it.
My lord.
That's why I give time to the council to figure out whether they want.
My lord, in that case, my lord, may I
Whether or not can answer your question. I'm closing and I'll deliver judgment.
my lord. In that case, my lord,
Therefore, do you want to clearly have a relook at your case and reformulate? You can still argue the matter. But if I make it part out, then I'm going to close it.
my lord, my friend, my lord, in that, some, my lord,
I mean, it's not to dissuade you, but it doesn't appear to me that you are prepared with the legal issues. I have read the pleadings. These pleadings will be difficult. And then you definitely don't have the decisions. Do you have a decision which says then authority higher than the disciplinary authority cannot pass the order of dismissal? Cannot drive home that point. Do you have the decision that
my lord, here the,
charge could have been levied on somebody else, so therefore I should be exonerated? You don't have the decision.
my lord, in that aspect, my lord, since it is quite fallen from your lordship, then, my lord, when, my lord, the rules specified the, my lord, the authorized person, and my person who is my appellate authority has passed the order, my lord, where should I go again? So when I go on to the other forum,
That's correct. So
Yes.
you have to establish that point.
yes, my lord,
Where should I go is not the answer. The
Yes,
answer is that he cannot pass this order.
yes, my lord.
That has to be
So
your.
therefore, my lord, the appellate
Then you have
authority,
to establish that point
Yes. by jumping the, my lord, the other provision, my other person, my lord, I cannot approach, my lord, the persons who is not at all, my lord, as per the procedure, my lord, given by the, my lord. So therefore, my lord, may I have some?
You establish that point. You're just saying he has passed, I cannot go. We can't pass rulings on that.
So in
Then
that
I have
case-
to do my own research and pass a judgment. That I cannot do in Arunachal. Because I'm here for 2-3 days.
My lord.
In Guwahati, I would have done it. Or you come to Guwahati to transfer the matter.
My lord.
I have a team of researchers, they do their research. We do a lot of research in writing a
Yes.
judgment. But here I can't do it. Here either you come prepared with your materials or it will be difficult because I don't have the wherewithal here to do my own research and then deliver a judgment in 2 days, 3 days time. That's not possible.
My lord, may I have another chance to have research on the
When you want it to post it when?
my lord, after a week or
After a week.
or 2 weeks.
All right. Have you understood the point?
My lord, correctly I understand.
The allegations are pretty serious.
Correct. my lord.
And it's not a case that there is perversity.
My lord, however, my lord, if the we,
He has allowed a convict to escape from the prison. And
Well,
he has
if-
given police uniform, etc. These findings are not challenged. You have not challenged these findings.
my lord, in the allegation is there, my lord, in the statement given by the other constable who was on that duty at the relevant point of time, has not, my lord, affirmed. My lord, from the, my lord, the statements of the other accused persons.
You have not challenged this finding of the
True, my
inquiry officer.
I understand. my lord.
That your
I
client
got,
has
my lord.
given uniform to the convict to escape through the ventilator. Mr. Kato, the problem is this court comes prepared reading the brief.
My lord.
Therefore, you have to come to the
I'm-
point.
Now, I'm highly obliged your lordship, is because the points, crux of the my lord has been pointed out your by lordship.
Make out a case
My
and get
lord,
an order.
admittedly, my lord, that part, my lord, of the findings of the my lord, that is not under challenge. my lord.
What is perversity?
My lord.
If the evidence points at north and the finding is at south, that's perverse.
Correct.
Or a conclusion based not on evidence, it's perverse. You don't have the pleadings on that. You are not even arguing. So first you must understand what is the legal issue.
Correct.
These cases should not take more than 15 minutes, but provided we are in the same page. You go in one direction and then I pass a judgment, then you think that, oh, the judge has not understood my case, not even appreciation. I don't want that to happen. Otherwise, it's very simple. You argue for 15 minutes, I'll go to the chamber and pass a judgment. I don't want to do that. Disciplinary matters, the scope of 226 court is very limited.
My lord.
It is basically based on violation of Article 14 and 16. You have to show that this is the duty under the law They have not followed it. In my case, this is discriminatory. This is resulted in prejudice to my interest. Therefore, protect my rights under Article 14 and 16 and set aside the order, reinstate me. This is the fundamental argument.
Correct.
He has not done this, he has not done that. This will not help. You have to show how it has resulted into discrimination to your clients, how he was prejudiced.
Right.
If he has given uniform to the convict to escape through the ventilator by removing rods, what prejudice will cause to your client? Whether disciplinary authority is IGP or assistant IGP,
True.
as courts will get into all these things. So your first argument is a bad argument, and I guess that is your best argument. Therefore,
Well,
you better apply yourself a little more.
Well.
You better apply yourself a little more. When do you want it? This is the next week.
well, after 2 weeks.
After?
2 weeks.
All right. You come prepared on
Yes,
these
madam.
terms and get a good order.
Yes, madam.
But there is a scope in your case. I have seen something. On the request of Mr. M. Katol, counsel for the petitioner, let this matter be listed for hearing again after 2 weeks.
Lordship,
Is
3
GAT
weeks.
3 weeks?
I'm not in his
GAT?
session, Lordship. for
And
some
if
time.
GR, sir, is present on behalf of the state after 3 weeks. All
Okay.
right, you do your research. There
Yes.
are new judgments. If you can show prejudice, this is not a case of shockingly disproportionate punishment. Only ground is procedural irregularity.
Well.
You don't have any other case. Yes.
I'm
that's all.
deeply obliged, madam.